Ngayon po nagpipili. So, bali wala pa po tao. Pag nag-ano, hindi. Pinag po natin.
Kakablihan ko ulit doon. Maliit.
Sorry.
Sorry. Kala ko hindi pa, hindi pa nag-uumpisa. Sorry, kaya. Okay.
Tumaba lang ito.
Okay. Matik.
We are requesting everyone to settle down. We will start in 3 minutes.
Minsan minamanual.
Everyone to please. For the opening prayer to be led by the Honorable Bell.
Let us put ourselves in the presence of our Lord. Heavenly Father, we come before you today as servants of the people, entrusted with a solemn constitutional duty. As the Committee on Justice gathers to deliberate on the sufficiency in substance of the Cabrera impeachment complaint and to vote on the sufficiency in substance of the Zavala et al. Impeachment complaint and the Cabrera impeachment complaint, we humbly ask for your divine guidance. Grant us clarity of mind that we may carefully discern the issues before us. Grant us integrity of heart that we may be guided not by personal interest, political consideration, or public pressure, but by truth, fairness, and fidelity to the Constitution. Grant us courage to decide according to our conscience and the law, even when the path is difficult. Remind us that the task today is not to judge guilt or innocence, but to determine whether the allegations, if taken as true, are sufficient in substance under the Constitution and the rules of the House. Help us to remain faithful to this limited but crucial responsibility. May our deliberations be marked by respect. Respect for one another as colleagues, respect for the institutions we serve, and respect for the Filipino people who look to this committee to uphold justice without fear or favor. In a world troubled by division, conflict, and war, we also lift up to you nations suffering from violence and unrest. We pray for peace in lands torn by conflict, for the protection of innocent lives, and for leaders everywhere to choose dialogue over destruction. Let justice and mercy meet, and may peace prevail among nations. Lord, bless this committee with wisdom that builds trust in our democratic institutions. May our actions strengthen, not weaken the rule of law. May everything we do today be done in a spirit of humility and service. All these we ask in your holy name. Amen.
You may all sit down. The meeting of the Committee on Justice is hereby called to order. Since our today's meeting is a continuation of the yesterday's meeting, the calling of the roll is hereby dispensed with. The Chair shall address the Committee on Justice. Today is March 4. We reconvene the Committee on Justice on our third day of official deliberations on the impeachment complaints against Vice President Sara Duterte. Sa mga kasama natin dito at sa mga nanonood, our pace is deliberate because our duty is delicate. Hindi tayo narito para magmadali. Hindi rin tayo narito para magkubli. We are here to uphold the Constitution of the Republic of the Philippines, calmly, carefully, courageously. When we began on March 2, 4 complaints were referred to this committee. The first was set aside, pursuant to the 1-year bar rule. The second was withdrawn. Yesterday, we focused on the third impeachment complaint endorsed by Representative Laila De Lima. Yesterday, we discussed the substance of the third impeachment complaint. The allegations are not light matters. Misuse of confidential funds, bribery, grave threats, ill-gotten wealth, grossly disproportionate to lawful income, and acts allegedly undermining constitutional order. Representative Chel Jokno pointed us to disbursement documents bearing the Vice President's signature, raising questions of direct knowledge and accountability. Representative Joel Chua highlighted sworn affidavits referenced in the complaint, including testimony about procurement irregularities and the alleged handling of public funds. Meanwhile, Representative Rufus Rodriguez raised a constitutional question. Can a vice president be impeached for acts done while concurrently serving as Secretary of Education? The response from several members was clear. Public trust is indivisible. At that point, Representative Benny Abante gave us one of the most memorable moments of the hearing. He raised 2 hands and said, in essence, one hand may act separately from the other, but there is only one brain directing both hands. Dalawang kamay, isang utak, isang opisyal, isang pananagutan. You cannot divide accountability depending on which title is convenient. The Constitution speaks to the office, not the label. We also examined statements attributed to the Vice President that some characterized as conditional or not serious, Representative Bong Suntay even suggested that certain remarks were merely a joke or might fall under imagination. And that was when Representative Janice Digamo rose. She did not speak in anger. She spoke in memory. She reminded us that before the tragic killing of her husband, Governor Roel Digamo, there were threats, conditional at first, words, but words that became real. Her message was simple and powerful. Ang banta, lalo na mula sa mataas na opisyal, ay hindi biro. Threats from high office are never just imagination. They carry weight. They create fear. They can destabilize institutions. Yes, there were references to premonition on the first day and to imagination yesterday. At one point, an example involving a public figure seen in a mall was offered to illustrate the harmlessness of imagination. I will not dwell on that illustration. I will simply say this. This committee is not a forum of fantasy. Hindi ito sinihan. Hindi ito komedya. Ito ay pagdinig sa pananagutan. Let me say this clearly. Impeachment is not about premonition. It is not about imagination. It is about constitutional accountability. At this stage, we are not deciding guilt. Hindi pa ito hatol. The question before us is narrower but crucial. Are the allegations, if assumed true for purposes of this stage, sufficient in substance to warrant further proceedings? If the accusations are speculative, we must dismiss them. If they are trivial, we must reject them. But if they raise serious constitutional questions about public funds, abuse of authority, and violations of public trust, then we must not close the door prematurely. So today, we turn to the fourth impeachment complaint, endorsed by Representative Benny Abante and DS Paolo Ortega. Some allegations may overlap with the third impeachment complaint. Others may reinforce it. Our task remains the same. Determine whether it meets the constitutional threshold of sufficiency in substance. So we ask, is the fourth impeachment complaint consisting of 7 grounds or 7 articles sufficient in substance? Do the allegations rise to the level of impeachable offenses? Do these complaints meet the constitutional threshold to move forward? And importantly, are the allegations credible enough to justify moving forward with the process? Iyan ang tungkulin natin ngayon. And by the end of our deliberations today, it is my hope that this committee will consider all the arguments from day 1 until today, from March 2 until March 4, and be prepared to vote. on the sufficiency in substance of both the third and the fourth impeachment complaints. This is not about personalities. This is not about political convenience. Hindi ito laban ng kampo. Ito ay usapin ng konstitusyon. History will not ask whether this was comfortable. History will ask whether we were faithful to our oath. Kung sapat ang reklamo para umusad ang proseso, dapat natin itong ituloy. If the constitutional threshold is met, we should not be afraid to let the constitutional process move forward. Now, let us proceed, calm but firm, fair but fearless. Maraming salamat po. At this juncture, we direct our committee secretary to acknowledge the presence of the justice members, including the ex-officio members, including those who were deputized. Comsec, please.
Thank you, Your Honor. We would like to acknowledge the members of the Committee on Justice, Honorable Attorney Jervil Jinky Betrix R. Luistro, Honorable Jennifer A. Lagbas, Honorable Brian Poe, Honorable Jonathan Keith T. Flores, Honorable Isabel Maria J. Zamora, Honorable Franz Vincent F. Legaspi, Honorable Loreto S. Amante, Honorable Joel R. Chua, Honorable Ernesto M. Junicio Jr., Honorable Lordan G. Suwan, Honorable Munir M. Arbison, Honorable Bienvenido M. Abante Jr., Honorable Jude A. Asidre, Honorable Rufus B. Rodriguez, Honorable Ramon Rodrigo L. Gutierrez, Honorable John Attorney J.P. Padiernos, Honorable Rene Luis M. Ko, Honorable Janet L. Garin, Honorable Francisco Paolo P. Ortega, Honorable Christopher Sheen P. Gonzalez as Deputized Representative of Honorable Ronaldo V. Puno, Honorable Beverly Rose A. Di Macuja, Deputized Representative of Honorable Virginel G. Byron M.D., Honorable Raymond Democrito C. Mendoza, Honorable Ryan S. Recto, Deputized Representative of Honorable Yevgeny Vincente B. Emano, Honorable Lawrence R. Defensor, Honorable Julian Jam L. Baronda, Honorable Marlene L. Primicias Agabas, Honorable Zia Alonto Adjong, Deputized Representative of Honorable Patrick Michael D. Vargas, Honorable Ana Victoria Veloso Tuazon, Honorable Jose Bong J. Teves Jr., Honorable Munir N. Arbison Jr., Honorable Honorable J.C. M. Abalos, Deputized Representative of Honorable Marcelino C. Libanan, Honorable Percival Percy Sendanya, Honorable Antonio L. Tino, and Honorable Valfredo Arman R. D. Maguila Jr., Deputized Representative of Honorable Maria Carmen S. Zamora. That's all, Your Honor.
Before we proceed to the determination of sufficiency in substance of the fourth impeachment complaint, that is Cabrera impeachment complaint endorsed by the Honorable Abante and Honorable Ortega, we recognize the Honorable Bel Zamora.
Thank you, Madam Chair. This is for the information of everyone, we are discussing or deliberating on the sufficiency and substance of the fourth impeachment complaint. As such, I remind you of Rule 3, Section 5, Determination of Sufficiency and Substance. It states here that the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. What we are looking for, Madam Chair and dear members and colleagues, we are looking for overt acts of the respondent that will show the nexus with the impeachable offenses as stated in the Constitution. Kailangan po natin makita o maipakita na ang impeachment complaint ay may overt acts o yung mga ginawa mismo ng respondent. At ito ay may connection o mangangahulugan na ginawa niya ang mga impeachable offenses sa Constitution. Yun lang po, Madam Chair. Thank you.
Before we proceed, we acknowledge the presence of the Honorable Arnan Panaligan from the 1st District of Oriental Mindoro. At this juncture, we open the determination of sufficiency and substance of the fourth impeachment complaint. To begin with, we recognize the endorsers of the fourth impeachment complaint, the Honorable Benny Abante and the Honorable Paolo Ortega, to make their manifestation with respect to their position on its sufficiency in substance.
Madam Chair, may I be allowed to please give my opening
You may
remarks?
proceed, Honorable Abante.
Madam Chair, distinguished colleagues, at mga kababayan po na nanonood ngayon sa ating live streaming, the Constitution of the Republic of the Philippines begins with a simple but powerful principle. Ito'y inuulit-ulit po natin to. Public office is a public trust. Na gusto ko nang dagdagan na hindi lang po ito public trust, kundi isang sacred trust, sapagkat hindi natin maikakaila na ito po'y bigay ng Panginoon sa atin. Hindi ito yung slogan. Hindi ito dekorasyon sa ating mga dokumento. Ito ang pundasyon ng ating demokrasya. In a democracy, leaders are accountable to the people. In a democracy, no official, no matter how powerful, is above the Constitution. And that is precisely why the Constitution gave Congress the power of impeachment. Because without accountability, democracy becomes something else. Without accountability, a republic begins to resemble a kingdom, where those in power answer to no one. We are not a dictatorship, Madam Chair. We are a democracy where we believe that we must be governed by laws made by Congress. Impeachment exists so that the people, through their representatives, Madam Chair, may ask the most serious question that can be asked of a public official. Are you still worthy of the trust given to you by the Filipino people? That is the question before us today. Let me be very clear. This proceeding is not about personalities. It is not about political factions. And it is certainly not about the political ambitions of someone who will run 2 years from now. It is about her responsibilities to the nation because of the office she occupies today, Madam Chair. It is about whether the serious allegations contained in this complaint deserve the full and sober examination that the Constitution requires. The complaint endorsed before this committee presents several grounds for impeachment. Let me explain them in the simplest terms possible so that every Filipino listening can understand what is at stake. Dahil kailangan malaman ng ating mga kababayan na hindi biro ang mga akusasyon laban sa Vice Presidente. Unang-una, the issue of transparency and unexplained wealth. Our Constitution requires public officials to disclose their assets through their statements of asset, liabilities, and net worth, what we call as SALN. Now, why is this important? Because the Filipino people deserve to know that those who serve them are not secretly enriching themselves. If a public official earns a certain salary, but their wealth grows far beyond what the salary could reasonably explain, then the people have the right to ask questions. This complaint alleges that certain bank accounts, property transactions, and cash holdings were omitted or understated in the Vice President SALN. It further raises the possibility that her accumulated wealth may be disproportionate to her legitimate income. Now, if these allegations are true, Madam Chair and my colleagues, that is not a mere clerical error. Hindi po ito biro. This is not a joke. That is what the Constitution calls culpable violation, a willful disregard of the duty of transparency. Pangalawa, the alleged misuse of public funds. The complaint cites findings from the Commission on Audit regarding the use of confidential funds under the Office of the Vice President and the Department of Education. Let us put the numbers in perspective, Madam Chair. More than 612 million pesos in confidential funds were placed under the authority of the Vice President across these offices. And one particular transaction has raised serious questions. 125 million pesos allegedly encashed and liquidated within just 11 days in December of 2022. 11 days, Madam Chair. In ordinary life, if someone withdrew that much money and claimed it was all spent in just a few days without clear receipts, without verifiable pays, people would naturally ask, saan po napunta ang pera? Oh, according to the complaint, some liquidation documents contain defective receipts, unverifiable pays, and irregular documentation. These are not small accounting errors, Madam Chair. Hindi po ito biro. Again, this is not a joke. When public funds are involved, every peso belongs to the Filipino people, and when hundreds of millions are spent without clear accountability, the public has the right to demand answers. Madam Chair, that is not free money. That is not a money coming from our own personal pockets. That is the money of the Filipino people. Di ba? The public money, akin nabanggit kahapon, is also a public trust. Kaya nga ang pangatlo, betrayal of public trust. This is one of the broadest grounds for impeachment in our Constitution. It refers to conduct that may not always fit nearly into criminal statutes, but nonetheless shows gross faithlessness to the public trust. And one allegation in this complaint is deeply troubling, Madam Chair and my dear colleagues. The Vice President publicly admitted that she had spoken to someone about killing the President, the First Lady, and the Speaker should something happen to her. Later, it was said that this merely was a joke. But let us be honest, threatening the life of the head of the state is not something that can be brushed aside as humor, particularly if this was even stated by the second holder of the authority of the land. Hindi po ito biro. This is not a joke. This is not what a wife can say to the husband, papatayin kita sa loob ng kwarto. Madam Chair, when the second highest official in the land speaks of assassination, even conditionally, as said by Congresswoman Digamo, it shakes the foundation of public trust because leadership carries weight. Words from high office carry consequences. Tanungin natin ang ating mga kababayan, if you had a neighbor who worked as an employee in a government office and your neighbor posted a video saying he was planning to kill you, hahayaan mo lang ba? Or would you not want to report that person to his superiors and have him held accountable for his actions? Once again, gusto kong sabihin, hindi po ito biro at hindi po ito dapat magiging katawa-tawa sa lahat. This is not a joke. Number 4, allegations of corruption and bribery. The complaint also presents evidence suggesting that public funds may have been distributed through intermediaries, including testimony from individuals who claim to have transported large sums of cash. These are also allegations of payments connected to procurement decisions. Now, whether these claims ultimately prove true is something that must be determined through evidence. But when sworn affidavits, audit findings, and documentary records raise serious questions about how public funds were handled, Congress cannot simply look away. Because the Constitution does not allow us to look away. Precisely why there is Congress in this country. It commands us to act. Now, some may ask, why impeachment? Why not leave this to the courts? The answer is simple, Madam Chair. Because impeachment is sui generis. It is unique. It stands alone. It is a unique constitutional process. Criminal courts determine guilt and punishment, but impeachment answers a different question. Is this official still fit to hold the trust of the Filipino people? That determination belongs to Congress. Ladies and gentlemen, belongs to Congress. Others will say that a previous impeachment complaint was dismissed. That is true. But that decision was based on a procedural technicality involving the one-year bar rule, not on the merits of the allegations. This complaint presents new evidence, including issues involving SALNs and unexplained wealth that have never been adjudicated. The Constitution demands that these allegations be examined. And finally, Madam Chair, my dear colleagues, some will say that this process is political. To that, I say, impeachment is indeed political in the sense that it is entrusted to elected representatives. But it is not partisan. It is political in the same way that democracy itself is political, Madam Chair, because it involves the people's right to hold their leaders accountable. Our duty here is simple. It is not to convict, it is not to condemn, but to determine whether these allegations deserve the full process that the Constitution provides. If we refuse even to examine them, we send a dangerous message that powerful officials can evade scrutiny simply by attacking the process. But if we proceed with fairness, sobriety, and respect for due process, we affirm something far more important than any political victory. We affirm that in the Philippines, the Constitution still reigns supreme, and that no one, not even the Vice President, is above the law. Why? Because public office is both a public trust and a sacred trust. Uulitin ko po, Madam Chair, hindi po ito biro. This is not a joke. This is a solemn responsibility. And perhaps these words would also issue a warning to some of our colleagues that will make stupid analogies, Mr. Chair. I would not hesitate even to question that. Ito po, seryoso po ito. Gawin nating seryoso ang impeachment complaint na ito. Maraming salamat po, Madam Chair and my dear colleagues.
Thank you, Honorable Abante. May we know if the Honorable Ortega wishes to deliver a manifestation as well?
Yes, Madam Chair.
You may proceed.
I would join my co-endorser with a short manifestation. We endorse this complaint out of respect for our Constitution, and we carry this responsibility in the House of Representatives. This is not about declaring anyone guilty. It is our duty, and it is straightforward. For us to examine the facts and determine whether they are enough and there is enough basis to elevate it. If the evidence supports it, we elevate it. If it does not, we dismiss it. We owe the Filipino people a process that is fair, steady, and faithful to our mandate. Maraming salamat po.
Thank you. As pronounced during day one of our proceeding, we will be deliberating on a per ground basis, although we will be voting on the basis of the entirety of the complaint. We will now proceed to the deliberation per ground of the fourth impeachment complaint. Please allow the chair to read Article 1. Culpable violation of the Constitution, betrayal of public trust, and other high crimes, citing the following specific offenses: assassination plot, sedition, and subversion of constitutional order. We are now opening the floor for opinions, comments, and manifestations of the Justice members.
Madam Chair.
The Honorable Franz Legaspi.
Madam Chair, just a short manifestation before I make a motion with regard to yesterday's discussions. Madam Chair, just like to manifest, similar to my manifestation yesterday with the Honorable Laila de Lima's own complaint, that we confine, or rather I address this to the committee members, that we confine our discussions to the facts recited. I would also like to manifest, based on my observations yesterday, that we uphold the respect, the dignity, and decorum that this committee deserves, that our chamber is expected to have. The nation is watching us, and I still ideally believe that as public officials or even law practitioners, that people will look up to our characters as examples to look up to, and how we will act today, how we will treat others and speak about others will ultimately shape the values of our people, especially to my fellow youth, in the years to come. With this, I wish to reiterate that we confine our manifestations to relevant statements, that we maintain our discussions to the facts recited, and have a fruitful, respectful, and dignified discussion ahead. With this, I move that the discussions yesterday, as they are similar to the impeachment complaint today, be adopted as well for the Cabrera impeachment complaint, as the grounds in both complaints are very similar. Thank you, Madam Chair.
There is a motion to adopt the discussion yesterday on the sufficiency in substance of the third impeachment complaint. In our today's deliberation, in the sufficiency in substance of the fourth impeachment complaint with respect to similar grounds appearing in the two impeachment complaints. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. The discussions yesterday in the sufficiency in substance of the third impeachment complaint is adopted for the purpose of the determination of sufficiency in substance of the fourth impeachment complaint. May we know if there are Justice members who wish to comment or manifest on the first ground.
Madam Chair,
The Honorable Zamora.
let me just point out the specific paragraphs in the fourth impeachment complaint that refer to the impeachable offense charged. We find the acts under paragraphs 85 to 111, and these are all about the assassination plot. For the record, Madam Chair, thank you very much.
Before we proceed, we would like to acknowledge the presence of the Honorable Deputy Speaker Jefferson Conghun, the Honorable Deputy Minority Leader Jesus Manuel Bong Suntay, the Honorable Deputy Majority Leader Eliza Micaela Mica M. Gonzalez, the Honorable Deputy Minority Leader Stephen James T. Tan, the Honorable Congressman Jose Joboy S. Aquino II from the Lone District of the City of Butuan. We likewise acknowledge the Honorable Deputy Majority Leader Vincenzo Renato Luigi R. Villafuerte. We acknowledge as well the Honorable Deputy Minority Leader Reynolds Michael T. Tan. We acknowledge as well the Honorable Congressman Robert Nazal from BH Party List. We acknowledge also the Honorable Deputy Majority Leader Maria Alana Samantha T. Santos. We acknowledge as well the Honorable Congressman Vincenzo Renato Luigi Villafuerte, acknowledged already. We also acknowledge the Honorable Deputy Majority Leader Hill Cabarangay A. Acosta Jr. And finally, we acknowledge the presence of the Honorable Terry L. Ridon from the Bicol Sara Party List. We acknowledge also the Honorable Deputy Speaker Yaser Alonto Balindong. And finally, we acknowledge the presence of Senior Deputy Minority Leader, the Honorable Laila De Lima. We are now opening the floor for comments, further comments and manifestations of the Justice members with respect to the first ground of impeachment of the fourth impeachment complaint.
Madam Chair,
The Honorable Joboy Aquino.
I'd like to make a manifestation, Madam Chair, in regards to the first question. Does the first ground of impeachment of the fourth impeachment complaint contain a recital of facts constituting the offenses charged and demonstrative of the jurisdiction of the Committee on Justice? Madam Chair, I do believe the answer is yes, that the first ground contains a recital of facts constituting culpable violation of the Constitution, betrayal of public trust, and other crimes when VP Duterte admitted to contracting an assassin to kill the President, First Lady, and the former Speaker of the House of Representatives. Second, what are the recital facts of that constitute culpable violation of the Constitution, betrayal of public trust, and other high crimes. The complaint contains an allegation that VP Duterte, during a live press conference which was showed yesterday, Madam Chair, publicly declared that she had already asked a person to take revenge, and that if I get killed, patayin mo si BBM, si Liza Araneta, at si former Speaker Martin Romualdez. No joke and no joke. Thank you, Madam Chair.
Thank you, Honorable Joboy Aquino. Any other member who wishes to manifest on the first ground? If there are no other members, the Honorable Suntay.
Thank you very much, Madam Chair. Kagaya ho ng aking binanggit kahapon, dito naman sa pang-apat na impeachment complaint, ang pangunahing allegation ng complaint ay nagsasaad, respondent publicly declared during a live broadcast press conference that she has arranged for a person to kill President Marcos Jr., the First Lady, and the former Speaker Martin Romualdez, if she is killed. Ito ang ginawang basihan ng Article 1 para sabihin may culpable violation of the Constitution, betrayal of public trust, at other high crimes. Pero kapag sinuri ito sa ilalim ng Rule 3, Section 5 ng Rules of Procedures ng impeachment proceeding, may malinaw na problema sa sufficiency in substance. Ang requirement ng rule ay may recital of facts constituting the offense charge. Hindi sapat ang statement na controversial or politically shocking. Sa complaint na ito, ang allegation ay speech lamang. Walang alegasyon na may actual hitman na kinuha. Walang maipakitang may agreement nga o conspiracy na ipatupad dito. Wala rin naipakitang may payment o arrangement na ginawa in order to facilitate such statements. Wala rin maipakitang weapon procurement o alleged overt act. Sa ilalim ng constitutional law, malinaw ang doctrine na kahit incendiary, inflaming, or shocking ang speech, ito ay protected under the freedom of speech. Naipailalim to sa Brandenburg versus Ayo na sinabi ng korte that the speech can only be punished if it is directed to inciting or producing imminent lawless action and likely to incite or produce such action. Ang parehong principle ay kinilala sa Philippine jurisprudence tulad ng Salonga versus Cruz Paño kung saan sinabi ng Supreme Court na kahit radical o disturbing a statement ay hindi punishable kung walang imminent and lawful action. Sa madaling salita, kahit pa matapang, galit, exaggerated ang political rhetoric, hindi automatic na ito ay krimen. Ang complaint ay umaasa sa interpretasyon ng statement, hindi sa factual acts constituting treason, sedition, or conspiracy. There is a Latin maxim, conclusion non probat factum. Ang conclusion ay hindi proof ng fact. Thank you.
The Honorable SDML Noy Defensor.
That's wrong, Madam Chair. We are discussing on the sufficiency and substance and the irrelevant, illogical statements made in defense has no point because this is a direct threat to the life of the sovereign. And the allegation that the Vice President has contracted an assassin who is prepared to kill the President, whether or not there is a condition, as alleged in both complaints, I have seen the evidence, and I have seen all the supporting documents, and this allegation is trial ready. Madam Chair, I move that we proceed to the next allegation.
Madam Chair.
The Honorable Is that a motion, Honorable Defensor?
Yes, it's a motion to proceed to the next allegation.
I object, Madam Chair.
Second.
There is a motion.
Let us give a chance to everyone to speak on each ground. And my good friend, and whom I respect so much, should be minded to withdraw that because precisely there are others who wish to speak. And we cannot stifle any member of the Justice Committee. And our chairman has always allowed everybody to speak until everybody has spoken in this committee. So we appeal to my good friend to withdraw that so that we can
Only
proceed.
because the Honorable Rufus Rodriguez has requested me to withdraw. I would gracefully withdraw my motion, Madam Chairman.
That is a statesman. You see, Mr. Chairman, our deputy majority is a statesman.
Just for the record, the motion to proceed to the next ground has been formally withdrawn.
Thank you, Madam Chair.
All the manifestations of the Justice members are duly noted. At this juncture, we recognize the Honorable Nazal and then Honorable Chua.
Thank you.
How about me?
And then Honorable Rodriguez.
Third, that is fine.
Good morning, everyone. Thank you, Madam Chair. Consistent with the constitutional threshold articulated under Article 11 and the ultimate facts rule applied during the PBBM proceedings last February 4, 2026, I respectfully submit that Article 1 of the fourth complaint fails the test of sufficiency in substance. The allegations rely principally on public statements characterized as an admission of contracting an assassin. However, even assuming hypothetical admission of the pleaded facts, the complaint does not set forth the essential elements of an indictable offense. There is no identification of an alleged assassin, no pleaded meeting of minds, no overt act towards execution, no defined consideration, and no operational step taken beyond speech. Conspiracy requires implementation elements. Sedition requires overt acts. Culpable violation requires a specific, willful breach of a constitutional duty. None are pleaded with particularity. General invocations of a constitutional order and oath-taking cannot substitute for a clearly identified constitutional provision willfully violated. Under the standard consistently applied in the PBBM proceedings, rhetoric, however alarming, does not become an impeachable offense absent ultimate facts establishing execution. Accordingly, Article 1 rests on inference and conclusion rather than pleaded ultimate facts and is insufficient in substance. I so manifest. Thank you, Madam Chair.
Thank you. Next is the Honorable Chua.
Thank you, Madam Chair. Madam Chair, mukhang nalilito po yung mga kasama natin. Wala po tayo dito para determine yung criminal aspect ng complaint. Nandito po tayo para tignan natin kung pag binasa po natin itong facts, ito po ba papasok as impeachable offense? Now, let me clarify this. Ito pong Article 1 makikita po natin sa paragraph 83 pababa. At dito po, sa paragraph 85, dito po, clearly and expressly, binanggit po dito yung kataga na binanggit po ng ating Vice Presidente. At ano po to? Already as a person to take revenge and that if I get killed, patayin mo si BBM, si Lisa Araneta, at si Martin Romualdez. No joke, no joke. Now, paano po ito papasok bilang impeachable offense? Sabi po dito, sa same impeachment pa complaint, sabi po dito, makikita natin to sa paragraph 91 to 93. Ano po to? Meron daw pong culpable violation ng Constitution. Now, ano po yung specific provision sa ating Constitution ang binayolate? So makikita naman po natin to sa Article 7, Section 5. Dahil dito po, sa Article 7, Section 5, nakasaad po dito ng ating saligang batas, and I quote, Madam Chair, before they enter on the execution of their office, the President, the Vice President, or the acting President shall take the following oath or affirmation. Ang second paragraph, ito po yung kanilang oath. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as President or Vice President or acting President of the Philippines, preserve and defend its Constitution, execute its law, do justice to every man, and consecrate myself to the service of the nation. Defend its Constitution and execute its laws. Definitely, yung pagbabanta po is not a form of executing its laws. And therefore, there is a clear violation and culpable violation of the Constitution. Second, sinabi po dito at binanggit din po dito sa complaint, betrayal of public trust. At dito po defined under paragraph 94, the Supreme Court has defined betrayal of public trust as a catch-all ground encompassing acts that constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary power to the prejudice of the public interest. Gross faithlessness, pagtataksil sa tiwala ng publiko. Definitely, yung pagbabanta po sa ating Papangulo, sa First Lady, at sa ating Speaker, ay maliwanag na pagtataksil. Dahil itong tao po, yung Pangulo po natin, ay pinagkatiwalaan at hinalal para mamuno po sa ating bansa. We have to look at the surface. Hindi ko po sinasabi na guilty na. Dahil yung guilty or not, yung trial po yan sa Senado. Ang nandito lamang po ay by mere narration of facts. Sa pagbabasa lamang po ba neto, eh meron po bang grounds na na-violate? I submit, Madam Chair.
Thank you, Honorable Chua. Before we proceed, we acknowledge the presence of the Honorable Congressman Jose Manuel Tadeo Chel Jokno from Akbayan Party List. We acknowledge as well our Deputy Speaker, Honorable Raymond Democrito C. Mendoza. And finally, we welcome and acknowledge our Senior Deputy Speaker, the Honorable Ferdinand L. Hernandez, of course, from the 2nd District of South Cotabato. Thank you for coming to all the Kongs. Now we proceed. We acknowledge the Honorable Rodriguez.
Thank you, Madam Chair. Article 1 is based on three grounds for impeachment. First is the culpable violation of the Constitution. Second, betrayal of public trust. And third, other high crimes. To support these three grounds for impeachment, as found in our Constitution, it has three acts that are alleged to support these three, and which are assassination plot, sedition, and subversion. Let us go first to subversion, not as a crime itself, but as a support to the three, either of the three. And so, subversion, Madam Chair, was precisely made illegal in 1937 under Republic Act 1700. However, subversion, like in this case, they state subversion of constitutional order, subversion, Republic Act 1700, was repealed precisely in 1992 during democratic times. In 1992, Republic Act 7636 removes subversion. It cannot be a crime nor a support now to the three grounds that we have. Completely repealed in 1992, the subversion aspect of an act of a Filipino. Then we have sedition, Madam Chair. Sedition is an act of publicly uprising and tumultuously engaging in acts to really remove the established government and officials. So it cannot be because Sara Duterte did not publicly rise with arms to be able to remove the present government. Probably what they want to say is inciting to sedition. Because sedition itself is governed by our Article 139 of the Revised Penal Code, the rising publicly and tumultuously. If you go to Article 142, this will be inciting to sedition, but there is also no recital of facts that the Vice President made speeches or made publications to say, let us remove the present administration. Nothing. In fact, yesterday, if you see the video, she was just present. When her father spoke. Second, when Kibolo had a mass at a gathering, but she did not speak there. So therefore, against the present government. So these two are out, definitely out. Subversion of constitutional order is no basis to say there is violation of the Constitution, nor sedition or even inciting to sedition. So we now go to assassination plot. Here we go. This is what is cited in the first paragraph on factual allegations is under the page 28, paragraph 85. Ito na. Already asked a person to take revenge and that if I get killed, patayin mo si BBM, Lisa Raneta, at si Martin Romualdez. No joke. Now, we have to distinguish, Madam Chair, between conditional threat and threat with a condition. This is defined by the Supreme Court. What is a conditional threat and what is threat with a condition? Example of a second one. Threat with a condition. I will kill you if you give me 1 million pesos. That is a threat with a condition. There's still liability. However, conditional threat, like I'll kill you if I am killed, that is a threat from the grave, so-called. Even, Madam Chair, even the late presidential legal advisor, the late Juan Ponce Enrile, I saw him in an interview. He said there is no crime because it is conditional. The entire, statement about killing somebody only arises if you are dead, and both of them are very much alive. However, this is now the situation, Madam Chair. The one who said it is the Vice President. The persons where the conditional threat is being mentioned is the President, the First Lady, and the Speaker. And so this committee will have to therefore decide whether that reaches the sufficiency of form and substance. Thank you, Madam Chair.
Madam Chair.
The Honorable Zamora.
Madam Chair, I'd like to make another manifestation regarding Article 1. Article 1 of the fourth impeachment complaint. I was part of the prosecution team in the last impeachment, and I handled this. And we saw the evidence of the NBI. In fact, for the information of everyone, this went to the NBI. The NBI filed a case, and they have the evidence. Now, that threats were conditional, is inconsequential. We heard what the Honorable Janice Degamo said yesterday, and I believe that, well, we were all touched and maybe disturbed by what she said yesterday. She said that their family received threats, conditional at the start, but in the end, the threats became real and her husband was murdered. The video that we are talking about was viewed by everyone, including international media, international persons. This happened on the 23rd of November, 2024, early morning. And we all saw how the Vice President hurled expletives and publicly admitted that she had set into motion a clear plot to assassinate the President, the First Lady, and the former Speaker of the House. These acts, Madam Chair, are stated, as I said earlier, in paragraphs 85 to 111 of the impeachment complaint. It is clear that the overt acts that we are looking for are in the impeachment complaint. The video that we are all talking about was mentioned in the annexes, or was it? Yes, it was mentioned in the annexes of the complaint. And for everyone's information, this is what we call res ipsa loquitur, or the thing speaks for itself. Everyone heard what the Vice President said, and again, these are mentioned in the impeachment complaint. So we do not go into the elements of the different crimes of the revised penal code, but the mere act, Madam Chair, that she said these words and that she contracted an assassin is impeachable in itself. That's all, Madam Chair. Thank you very much.
Thank you. Any other member who wishes to manifest?
Madam Chair, can I be allowed to speak?
This will be your winding up as well, the Honorable Abante.
Yes.
After this, we will be proceeding to the second ground. The Honorable Abante is recognized.
Upon hearing the statement of Congressman Rufus, medyo umiikot po yung aking isipan tungkol dito sapagkat nakalagay naman sa impeachment complaint natin yung bang grossly inconsistent with the dignity of her office. Now, the question is, proper dignity ba yung statement ni Vice President Sara when it comes to assassination threat? Na hindi lamang assassination threat, Madam Chair, assassination plot, sapagkat meron na po siyang hinire na assassin. Sinabi niya sinabi niya, hindi joke yan. Pangalawa, yun po sinasabi natin gross exercise of discretionary powers. Yun po ay kasama pa sa tinatawag na discretionary powers ng Vice President to threaten the President. Hindi na pinag-uusapan dito yung sedition o saka yung subversion. Ang pinag-uusapan po dito yung dignity ng office ng Vice President, yung discretion powers ng Vice President. Yun po ba ang tinatawag natin? Dapat ba na ito ay gawin nating baliwala, Madam Chair? So while the VP may claim her remarks were not serious, a high-ranking official threatening the life of the head of the state is a high crime and a threat to national stability. Yaman po.
Thank you. Now we proceed to Article 2 of the fourth impeachment complaint. Please allow the chair to read. Betrayal of public trust and graft and corruption. Among the offenses cited are misuse and malversation of confidential funds, violation of Joint Memorandum Circular number 2015-01, COA findings, and falsification of documents. Now we elicit the comment and manifestation of the Justice members.
Madam Chair,
The Honorable Rodriguez.
Bong Sonta is not here, so I just go ahead, because he would have been first always. Madam Chair, on Article 2, it is betrayal of public trust and graft and corruption. I would just like to take exception in accordance with what I stated yesterday. Page 34 includes the DepEd. And as I have stated, and I remind again members of the Committee on Justice, that we have no jurisdiction over actuations of the former Secretary of the Department of Education. So, page 934, we say that the statement of corruption by grossly abusing discretionary authority over confidential funds appropriated to the OVP, that's fine, but the statement that DepEd is totally out of the jurisdiction of this committee, the actuations of the former Secretary. Then on page, Madam Chair, on page 36, once again, 1223.3 paragraph, 125 million in DepEd confidential funds in the late 2022-2023. Again, DepEd, we cannot have jurisdiction over DepEd. The case of Duterte versus House of Representatives clearly state that the impeachable offenses must relate to the acts of the position and the office where the person is sought to be impeached. And we're not going to impeach the Secretary of a department here, but there is an allegation against her as the Vice President. So that is page 36. And then on page 38, we have here 129 paragraph. It says a random sampling of receipts and acknowledgement receipts submitted by the OBP and DepEd revealed numerous defects. So once again, the statement of DepEd, the statement about DepEd is that it is beyond our jurisdiction. And then also 132, several receipts, OVP and DepEd should not be included. Now, on page 39, there is this allegation of physical distribution and third-party deliveries, use of DepEd vehicles and personnel. Again, this is about DepEd. It could not be part of our investigation on the allegations of the impeachment. And so, Madam Chair, those are my observation on Article 2. Thank you very much.
Meanwhile, the Chair wishes to remind the Justice members, while we value the significance of all your arguments, we resolve already to adopt the discussion we had yesterday in the determination of sufficiency in substance of the third impeachment complaint for the purpose of our deliberation on the sufficiency in substance of the fourth impeachment complaint. We therefore encourage the members to raise new matters. Members who wish to manifest? The Honorable Chua and then
Madam Chair.
Honorable Tino,
Madam Chair.
Honorable Joboy Aquino, and Honorable Chel Jokno.
Madam Chair.
And Honorable Abante.
Madam Chair.
And Honorable Nazal. Honorable Chua first.
Thank you, Madam Chair. Madam Chair, as already manifested yesterday, I stand with my position that the Vice President, we should not distinguish between her position as Secretary of DepEd and Vice President by, again, citing the constitutional provision that under the Constitution, the Vice President may be appointed as member of the Cabinet, and such appointment requires no confirmation. So, meaning to say that the appointment of the Vice President as Secretary of DepEd is concurrent position. Hindi po siya ma-appoint doon if she were not the Vice President. And secondly, siya nga lang po ang nag-iisang Vice President, siya nga lang po nag-iisang Cabinet Secretary na hindi na kailangan ng confirmation precisely dahil siya po ay Vice President. And thirdly, in addition to those statements and for the information of the body, the Vice President as Secretary of the DepEd is not receiving any allowance or emolument as Secretary of DepEd. Therefore, and it is very obvious na kaya po siya nandoon, again, because of her position as Vice President. Having said that, Madam Chair, I would like also to point out that from the perusal of the second argument, sabi po dito, ito pong second ground anchored on the allegation that the Vice President has committed betrayal of public trust and graft and corruption. Now, paano po pumasok ito? Kung babasahin po natin, doon sa paragraph 1, 2, 3, sabi po dito, on 20 December 2022, Land Bank check number 224,244,027 in the amount of 125 million was issued to the OBP and in cash at the Land Bank, Shaw Boulevard by SDO Gina Acosta. So dito po sa paragraph na to, makikita natin, wala pa pong participation ng ating Vice President. Now, ito pong paragraph 1, 2, 3, this should be read in relation to paragraph 1, 3, 4. Dito po sa Madriaga affidavit, chain of custody. Dahil ito pong withdraw dito sa paragraph 1, 2, 3 na 125 million na in-encash na sinasabi na nilagay po sa mga multiple bags na nakalagay sa paragraph 125 na binigay po kay Dante La Chica ay binigay po kay Madriaga. At dito naman po si Madriaga, sinasabi po niya na ito daw duffel bag, 4 na duffel bag na kinuha niya ng cash sa Ultra Pasig City noong December 20, 2022. Take note of the date, Madam Chair. Ibig sabihin, ito rin yung araw kung kailan in-encash yung 125 million. Siya daw ay nag-deliver netong 4 na duffel bag sa various recipient, including a mayor in Laguna, an office in Timog, and a vehicle left at the Ombudsman parking compound for retrieval. At this point, wala pa rin pong participation ang ating Vice President. Now, paano po napunta dito? Paano po ito naging impeachable offense? Makikita po natin yan sa paragraph 150. Kasi dito po sa paragraph 150, nakalagay po dito, the OBP SDO's testimony that they were instructed to turn over cash to intermediaries, which is Nolasco to Madriaga, at the direction of respondent Sara Duterte supports direct liability. So dito po pumapasok yung participation ng respondent. Kaya po, dito po pumapasok yung grounds which is grave, which is betrayal of public trust and graft and corruption. So with that, pagbabasahin lamang po natin yung facts, makikita po natin na may sufficient in substance. That's all, Madam Chair.
We just want to share to the justice members that the Madriaga affidavit referred to by the Honorable Chua is part of the attachments, I think, of both the third and the fourth impeachment complaint. That's for the guidance of the justice members. Before we proceed, we would like to acknowledge the presence of the Honorable Zia Alonto Adjong from the 1st District of Lanao del Sur. We also acknowledge the presence of Deputy Majority Leader Crispin Diego D. Remulla. And we acknowledge as well the presence of Deputy Speaker David J.J.C. Suarez. To proceed, we would like to recognize the Honorable Joboy Aquino.
Thank you, Madam Chair. Earlier, Madam Chair, we've heard that from our good friend, Congressman Rufus Rodriguez, that we cannot, as Education Secretary, we cannot impeach her or no? Because they covered. But all I want to say, Madam Chair, is it is the same person also that is being accused of a crime to commit murder. No? What I'm trying to say, isang tao lang to. Pero ginagawa niya sa OVP, ginagawa niya rin sa DepEd. That's all. Simple lang yan, Madam Chair. Thank you.
Next is the Honorable Tino.
Thank you, Madam Chair. Madam Chair, initially I raised my hand in order to ask for clarification regarding the relevance of the initial motion that was carried, that the discussions on the third hearing that are relevant to the fourth complaint are carried. No, so you already clarified that indeed they are carried, and therefore we do not need to spend so much time recapitulating the arguments that were already raised yesterday, including this argument of our esteemed Dean of Law and colleague, Dean Rufus, Congressman Rufus. No? So he mentioned again the argument about the Vice President as against the Deputy Secretary. And so we don't have to go through the debates again. No? And I would just like to say that once again, my position is that we are not impeaching the Deputy Secretary, which would be absurd, but the Vice President carrying out her function as a member of the Cabinet as provided for in the Constitution, no, as Deputy Secretary. So yun po ang ginagawa natin dito, kaya nasa jurisdiction po yan ng komite. Ngayon, regarding the second article in the complaint, I believe that it is sufficient in substance because the allegations here are betrayal of public trust and committing acts of graft and corruption by grossly abusing discretionary authority over confidential funds appropriated to the OVP and DepEd, causing or permitting the fabrication and submission of implausible liquidation documents, and directing the physical transfer and distribution of large cash sums outside lawful accounting channels, and by obstructing audit and congressional oversight. So, kompleto po yun, no? Mula sa pag-abuso sa confidential funds hanggang sa pagtatakip ng abusong ito sa pamamagitan ng pagpeke ng mga dokumento na sinabmit sa COA at ang pagtutol niya o pagtanggi niya na magpaliwanag sa Kongreso sa paggamit nito. And from paragraphs 121 to 122.3, yun po yung tungkol sa 125 million na naubos in 11 days. Tapos from paragraphs 129 to 133, ito naman po yung tungkol sa fabrication of accomplishment reports. And from paragraphs 138 to 140, ito naman po yung tungkol sa refusal of congressional oversight. So I believe, Madam Chair, sufficient po yung allegation of facts to support betrayal of public trust and graft and corruption. Thank you, Madam Chair.
Thank you, Honorable Tino. Next in line is the Honorable Chel Jokno.
Thank you, Madam Chair.
while I continue to respect Congressman Rufus Rodriguez despite his comments about law deans, I have to disagree with his argument. First of all, because if we carry that argument to its logical conclusion, it would mean, for example, that if a vice president were to attend a function as Secretary of Education, where the president was also present, and then, let's say, hypothetically, were to brandish a firearm or even discharge it at the president, then does that mean that she cannot be impeached? Second, if we carry that argument, then that would mean that the vice president could easily hide behind that distinction and commit plunder, commit other high crimes as Secretary of Education, and there would be no accountability. So I really must disagree. It's impossible to distinguish those two positions. Thank you, Madam Chair.
For the guidance of the members, the exchange of argument is with respect to the jurisdiction of the Justice Committee with regards to the offenses committed as Secretary of Department of Education, as to whether or not they can still be considered as within the jurisdiction of the Justice Proceedings, Justice Committee proceedings with respect to impeachment offenses. Next is the Honorable Benny Abante.
On the issue of, just like what my good friend Congressman Rufus said, the VP Sara, as Deputy Secretary, is not an impeachable officer, and therefore the House Committee on Justice has no jurisdiction over her. No. Now, to me, that would be a clever technical argument. Kaya ako ngayon nag-aaral na ng law. Kaya hindi ako abogado dahil si Congressman Rufus, magaling talaga ito. Kaya can you imagine, napupuyat ako sa pag-aaral. But anyway, Madam Chair, ito pong clever technical argument na ito, it intentionally confuses the position held with the person holding it. In the Philippine context, the House Committee on Justice jurisdiction is not determined by the status of the person being charged, not the specific desk they were sitting at when the act occurred. For example, nakita ko rin po yung tinatawag nating single personality doctrine. Ito po ang punto rito. You are not impeaching a secretary. You are impeaching the Vice President for her conduct while in public service. The Vice President does not have any split personality. Sino bang ating tinutukoy dito? Si Mr. Jekyll ba o si Dr. Hyde? Di ba? Not a split personality. She is a single impeachable officer. Whether she is performing her duties as the OVP or at DepEd, she remains the Vice President of the Philippines, Madam Chair. You cannot strip away her impeachable status just because she stepped into a cabinet meeting. If she commits graft as DepEd Secretary, tulad po na nabanggit ni Congressman Chel Jokno, she has committed graft as the Vice President, and that makes her unfit for office. Ito po ang punto. The Constitution identifies betrayal of public trust as a ground for impeachment. It does not say betrayal of public trust only in the performance of the office of the Vice President duties. If she used her position as a high-ranking official to mismanage DepEd funds or take bribes, she has betrayed the trust the people place in her as what? As the second highest official of the land. the House has jurisdiction because the person is an impeachable officer. Yun lang po, Madam Chair. Thank you.
Thank you, Honorable Abante. Next is the Honorable Flores.
Thank you, Madam Chair. Madam Chair, gusto ko lang sana may balik yung usapin no, about what the Justice Committee is about to be doing right now. I think the questions on whether she was doing it as Secretary ba or as Vice President should be totally left to the discretion of the Vice President whether or not she wants to use that defense. Dapat pagbigyan na po natin yung Vice President to choose kung gagamitin niya ba to as an issue in her defense or whether to ignore it. Wala po sa atin yan. Ang importante po is ibalik natin ang usapin sa ano ba ang trabaho ng Justice Committee. And our work only, Madam Chair, is to determine whether or not may sufficiency in substance po ba ang allegations that are stated in the impeachment complaint. So whether or not we have jurisdiction, as far as her position is concerned, whether as Deputy Secretary or as Vice President, I believe it is siguro our responsibility also to leave it to the Vice President whether to adopt this kind of defense or not, or even not to answer it at all, Madam Chair.
Thank you.
Madam
The Honorable Ridon.
Well, sa totoo lang ho, kahit hindi na ho natin pag-usapan yung split personality between Vice President and Deputy Secretary, siguro maganda pag-usapan na lang ho natin yung usapin po ng tenure. Kasi impeachable officials are impeachable within their tenure of office. No? So the Vice President has a tenure of office from June 30, 2022 to June 30, 2028. So ang tanong po, yung po bang mga impeachable acts, impeachable offenses, kailan po ito nangyari? Nangyari po ba ito within this particular tenure of office ng isang impeachable officer? Kung ang sagot po dyan ay oo, and quite certainly, yung pong acts niya, Vice President, happened during her tenure of office while she was Deputy Secretary, pasok po yun as impeachable acts and impeachable offenses while she is Vice President. Yun lang po, Madam Chair.
And of course, we recognize the Honorable Defensor.
Thank you, Madam Chairman. Para matapos na din itong usapin tungkol sa depensa na magkahiwalay ang personality nila, we simply have to go back to the enumeration under the Constitution na ang impeachable officers ay the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman without qualification, without exception, na nagsasabing unless otherwise they are appointed as DepEd Secretary or DNR Secretary. So that would be clear, and it's the Constitution itself that has laid down that enumeration to establish the jurisdiction of the committee. Maraming salamat, Chair.
Thank you. That concludes our
Madam
deliberation
Chair.
on the
Madam
second
Chair.
round.
Hindi pa ako natawag.
The Honorable Suntay.
On the alleged misuse of confidential funds, ginagamit ito ng complainant para ipakita na may misuse or malversation ng confidential funds. Pero mahalagang tandaan na ang paggamit ng confidential funds ay governed ng COA DBM Joint Circular 2015-01. Sa circular na ito, kinikilala na ang confidential funds ay ginagamit para saan? Surveillance activities, intelligence gathering, informant payments. Dahil dito, cash transactions talaga lahat yan. So hindi porket may mga cash transactions o may movement ng funds, ibig sabihin, meron ng malversation o merong corruption na nangyayari. Hindi rin pwedeng sabihin, bakit nagastos yung pera in 11 days as alleged? Dahil ang spending, yung bilis ng paggastos, hindi naman automatic, ibig sabihin, illegal na. Confidential operations often require immediate payments to sources like informants. Ang mas mahalagang problema sa complaint ay hindi nito pinapakita kung saan napunta ang pera. May personal benefit ba na pumunta o nakuha ang Vice Presidente? Wala sa complaint allegations na tumanggap siya ng bahagi ng pera. Walang nakasaad na may asset bang nabili using that funds? May bank transfer ba papunta sa kanya? Ang reliance ng complaint, kung babasahin natin, mula sa mga COA audit findings. Audit observation memorandum, notice of suspension, notice of disallowance. Pero sa ilalim ng COA audit rules, ano ba yung audit observation memorandum? Preliminary observation lang ito. Ano yung notice of suspension? Pagkulang ang dokumento. Ano yung notice of disallowance? Administrative finding. Pero ito,
Madam Chair, Madam Chair, point of order muna.
There's a point of order. Honorable Suntay, let's hear the point of order of the Honorable Abante.
Yung ba pinag-uusapan natin? Ano ko yung ba pinag-uusapan natin?
This is about confidential fund.
Oo.
Yes, this is about confidential
Ang
funds.
pinag-uusapan natin kanina,
Madam Chair, this is
Sandali
regarding
lang.
confidential
Let's
funds.
allow the Honorable Abante to finish the point of order.
ang pinag-uusapan natin kanina, kung yung office ng Secretary of Education, saka yung Vice President's office, impeachable offense ba yun?
Madam Chair,
Pinag-uusapan yun. Dali lang,
impeachment complaint.
nagsasalita pa
Kindly
ako.
wait until he
Ano?
finishes.
No. Binapaliwanag mo kung paano ginamit ang confidential fund. Hindi pa nga pinag-uusapan yan eh. Pangalawa, paliwanag. Dapat yan pinag-uusapan niya sa impeachment court. Hindi dito. Madam Chair, yun lang.
For the guidance of the Honorable Abante, there are allegations as to misuse of confidential fund in the office of the Department of Education with the Vice President as Secretary of Education. So, it is my humble submission that the manifestation of the Honorable Suntay is aligned to the deliberation on the second ground of the fourth impeachment complaint. The point of order is overruled.
Thank you very much, Madam
The Honorable
Chair.
Suntay may proceed.
And to my good friend, Congressman Abante, if I may continue.
You may. Thank you.
Hindi ito automatic proof ng graph of malversation. Ito ay consistent sa sinabi ng Supreme Court sa Navales versus People at Guillen versus People. GR numbers 219598 at 220108. Kung saan sinabi ng Korte na procedural irregularities on procurement violations do not automatically result in criminal liability or graft. Makikita rin, kagaya ng sinabi ng aking paboritong colleague, Congressman Joel Chua kanina, may nabanggit siya tungkol sa kay Madriaga, affidavit ni Madriaga. May tanong ko lang, nasaan ba si Madriaga? Di ba, nakakulong yata? So we are relying on an affidavit issued by an individual who is currently in prison. Now, sino ba si Madriaga? Meron ba siyang appointment kay BP Sara to prove that he is an employee or an authorized person? Para ma-direkta naman natin yung linkage nung dalawa. Kasi if we rely heavily dun sa affidavit niya, it should not come
Madam
from
Chair,
a polluted force.
point of
Madam
order.
Chair.
There's another point of order. Let's hear the Honorable Dilima.
Are we talking now here about the credibility of a prospective witness in these proceedings? We're not yet at the evidentiary stage. We're not yet supposed to judge whether or not Mr. Madriaga is credible. So it is premature and it tries to divert the matter now. We are just talking here about the confidential funds and also about the concurrent capacity of the Commission of Offenses of the Vice President in her concurrent capacity as Secretary of Education.
Madam
So let's
Chair.
not talk yet about whether or not worthy, whether or not credible, whether or not totoo yung sinasabi ni Madriaga. We have yet to hear from him, aside from this sworn testimony, of a sworn affidavit. So, that's out of order, Madam Chair.
Madam Chair,
The Honorable Suntay.
it is necessary to raise this because his affidavit is attached to the complaint and it is relied on heavily.
Nevertheless, the Honorable Suntay, please be reminded that we are only at the stage of the sufficiency in substance. We are not discussing yet the weight of the evidence attached.
Yes, I know, Madam Chair. I
The
just
point
want
of
to-
order is sustained.
Madam Chair,
Thank you very much, Madam Chair.
Madam Chair, just a quick rebuttal.
The Honorable Chua.
Thank you, Madam Chair. Madam Chair, I agree with the...
The Honorable Chua is reminded to refrain from further commenting to the manifestation which has been the subject matter of the point of order of the Honorable Dilima.
Thank you, Madam Chair. Madam Chair, this is just a recital of facts. By the reading of the affidavit itself, titignan po natin kung meron nga po talagang offense charge. At maliwanag naman po dito, meron pong perang nilabas, as cited in paragraph 1, in paragraph 1, 2, 3 of the complaint. And ito pong 125 million na binabanggit dito, sinabi rin po sa paragraph 125, ay pinasa sa kay certain Dante La Chica. At dito rin po sa complaint na to, maliwanag sa paragraph 134 na sinasabi po ni Madriaga na siya po yung kumuha nitong pera at diniliver niya. So, meron pong money trail na hinahanap po tayo. Now, bakit po nakunik ang Vice President? Kasi po, sinasabi rin po dito sa paragraph 150, sinasabi po dito na yung pong pagpapasa ng pera from the SDO to another na wala naman pong koneksyon ay upon the instruction of the Vice President. Now, dito rin po sa ating affidavit, nakalagay rin po dito at dinefine din po dito kung ano po ang definition o element ng graft and corruption. Nakalagay po yan sa paragraph 146. RA number 3019, paragraph 3A, penalizes public officers who persuade, induce, or influence another public officer to perform an act constituting a violation of rules and regulation. Definitely, yung pagpupunta po ng pera from one person other than the SDO is a violation of rules and regulation. Thank you.
Madam Chair, I start a quick
Thank you.
reply.
Before I call the Honorable Sontay, let me finish first with the list. The Honorable Nasal and then the Honorable Acosta.
Thank you, Madam Chair. Madam Chair, Article 2 likewise fails to meet the constitutional threshold of sufficiency in substance. The issues raised, particularly those concerning confidential funds, under Joint Circular number 2015-01, audit observation memoranda and notices of disallowance were substantially discussed during prior deliberations. Nung in-apply ng committee yung standards na ito during the PBBM proceedings, sinabi nun na ang preliminary audit findings are not final adjudications of liability. Audit observation memoranda and notices of disallowance remain appealable and subject to administrative and judicial review. Kaya standing alone, kitang-kita na these do not establish graft, malversation, or betrayal of public trust. Rapid liquidation by itself is not per se unlawful. Cash handling is intrinsic to the nature of confidential and intelligence funds. What must be pleaded are ultimate facts of unlawful conversion, personal appropriation, manifest bad faith, or a specific amount personally received by the respondent. Pag binasa yung complaint, wala naman naka-allege dito na essential elements. Puro inferences lang ang meron. Inference is not an ultimate fact. For these reasons, Article 2 likewise fails the insufficiency in substance threshold. Thank you, Madam Chair.
Next is the Honorable Acosta.
Madam Chair, while I agree to the Congressman Nazal and Congressman Bong Suntay that our findings are not criminal judgment, but are highly relevant in this discussion on whether or not pleaded facts in this fourth complaint shows an accountability breach. Our test here today for the members is whether the complaint, the fourth complaint, pleads objective audit red flags, which is the ultimate facts resided, supporting betrayal of public trust and that of graft and corruption, Madam Chair. The second question, Madam Chair, is for the two gentlemen who, Pastor Abante and Congressman Ortega. In their pleading, Madam Chair, one of the evidentiary value is JC number 2015-01, and in relation to that, notice of disallowance addressed to the VP, dated August 8, 2024. My question, Madam Chair, on whether or not Annex G2 or that notice of disallowance August 8, 2024 have already attained finality.
Would you like to comment, Honorable Abante? He's asking about the status of the notice of disallowance. I believe this is the 73 million of the Department of Education.
I think, Madam Chair, that the COA would have more of the right to answer that than us, no, because they're the ones that actually gave,
Honorable
the disallowance.
Acosta,
Thank you, Madam Chair. That's all.
are you done?
Madam Chair, would be able just answer the manifestation of Congressman Nazal?
Before I call you Honorable Abante, allow the chair to call first the Honorable Suntay.
Thank you. Just a quick reply to the statement made by our good friend, Rep. Joel Chua. Yung nabanggit niyang pera that went to La Chica and passed hands, that shows movement of funds. It is not a proof of illegality of use or personal appropriations of the said funds. In fact, the VP is a high-ranking official, and she relies heavily, and as well as other officials, on her subordinates, accountants, unless it can be shown and can be proved that she personally fabricated the receipts, she received the money, or she had gain from those funds. Then I believe that the allegation is not substantial. Thank you, Madam Chair.
Madam Chair.
Before I bring back to you the floor, Honorable Abante, since you are the endorser, let me finish first the other Kongs. The Honorable Ridon is recognized.
I think most of the matter has already been discussed yesterday. We are basically just reprosecuting the points that had already been raised yesterday. Even the defenses of the Vice President had already been stated yesterday, which is why the endorsers and the other congressmen are also reprosecuting the points, no? But I think, Madam Chair, even if we remove the Madriaga affidavit, the basis of the notice of disallowance, which remains pending before the Commission and Bank, can actually stand on its own as proof of the accountability of the Vice President in the misuse of confidential funds, no? So, wag na ho natin pag-usapan muna yung laman po ng paano ho yung from La Chica to Madriaga. Kahit tanggalin po natin yon, Madam Chair, titindig po yung usapin po ng malversation. Kahapon, sinagot na rin naman ho natin, hindi ho requirement sa malversation, sa different types of malversation, yung pong personal benefit. Totoo, meron po nga malversation that requires personal benefit. Pero in technical malversation, hindi ho depensa. Yung meron ho kayong personal benefit. The fact na meron hong maling paggamit doon po sa itinakda ng paggamit po ng pondo, technical malversation na po yun. May kaso na pong kriminal yun. At ano ho ba yung pinag-uusapan natin sa misuse of confidential funds? Ang pinag-uusapan ho natin sa misuse of confidential funds, tama ba na ginagamit po for what? For team building activities, yung pong confidential funds eh. Hindi ba? And finally, as an additional and new point, Madam Chair, one of the defenses relating to Madriaga, which is being, I think, stated today by the Office of the Vice President, is that Mr. Madriaga was never an employee of the Office of the Vice President. But I think the point needs to be made that in different parts of the bureaucracy, for example, yung mga contracts of service, yung po mga job orders, hindi naman ho yan technically empleyado ng mga opisina. Hindi ba?
So I don't think that stands as the defense that Mr. Madriaga is actually not an employee of any of the offices of the Office of the Vice President or when she was Secretary of the Department of Education. And finally, as a final point, yung po mga confidential agents, which is basically, I think, who Madriaga is. Yung mga confidential agents po ba are treated actually as employees of offices that actually implement confidential funds? I don't think so. So, this particular new development, which the Vice President is actually submitting as a defense on Madriaga, would not hold water, Madam Chair.
Thank you, Honorable Ridon. Before we proceed, we would like to acknowledge the presence of the Honorable Ana York P. Bondok from the 4th District of Pampanga. We acknowledge as well the presence of the Honorable Sara Jane I. Ilago from Gabriela Party List. And finally, we acknowledge the presence of the Honorable Congresswoman Rene Ann Lourdes Matibag from the 1st District of Laguna. Thank you for coming.
Chair.
To conclude our deliberation on the second round, I wish to express the significance of all your arguments, but let me manifest my observation as well that despite our resolve to adopt already our deliberation in the sufficiency and substance of the third impeachment complaint with respect to similar grounds, it appears that we are raising the same arguments and manifestations.
Madam Chair.
I understand that we value all your manifestations, but please allow the Chair to continue on encouraging you to raise new arguments instead. The Honorable Defensor.
Madam Chair, may I just remind the members of the committee that it is the intention of the framers of our Constitution that once an impeachment complaint has been initiated, the proceedings must be expedited. Madaliin, hindi para sagasaan, for two reasons. First, na kung wala naman palang kasalanan ang isang respondent, dapat mabilis natin ma-dismiss o mabilis siyang ma-acquit sa trial. At kung meron mang sa pre-trial pa lang o katulad nitong nasa committee pa lang, mabilisan din at huwag paulit-ulitin kasi kung masama at may kasalanan, dapat pumunta agad sa trial. I hope that we will not be redundant in our discussions for the succeeding grounds and that we will limit our manifestation simply to the recital of facts to determine whether there is sufficiency in substance. Thank you.
The Honorable Asidre.
Madam Chair, just to refresh the memory of the members who were probably not part of the investigations that were conducted last year, I do remember doing the interpellation of the disbursement officer, asking her who gave the instruction to transfer the said amounts to Colonel La Chica. And plainly and under oath, she manifested that it was the Vice President who gave that instruction. So clearly, Madam Chair, that being part of the attachments to the impeachment complaint, that provides a clear connection between the Vice President's instruction and the actions that were taken by the assigned officers.
Thank you. Next is the Honorable Gonzales.
Thank you, Madam Chair. I agree with the manifestation of our Senior Deputy Majority Leader. Kasi kung paulit-ulit po, yung oras o at panahon ay nasasayang, mas mayroon pa po tayong mas maraming pwedeng itakel na equally important matter po.
And we have 5 grounds remaining.
Thank you so much, Madam Chair. That's all.
To conclude our deliberation on the second ground, ibabalik po natin ang floor sa ating mga endorsers. Now we recognize the Honorable Benny Abante.
Madam Chair, just being able to answer the manifestation of Congressman Nasal, binanggit po niya kasi yung rapid encashment no, na hindi impeachable offense. No? Rapid encashment of 125 million in just 11 days in December 2022. Kaya nga po meron tinatawag tayong systematic irregularity because of this rapid encashment, no? The complaint includes evidence of fabricated or defective receipts and unverifiable pays used to liquidate confidential funds in both the OVP and the DepEd. That's the reason why naniniwala po kami dito sa impeachment complaint na ito. Salamat po.
Thank you. Now we proceed to the third ground of the fourth impeachment complaint. The chair will read graft and corruption, bribery, procurement irregularities, command responsibility, citing as specific offenses the following: malversation, failure to disclose, the accumulation of unexplained wealth, command responsibility and agency liability, pattern indicative of graft and unwarranted benefits, and finally, bribery and procurement-related corruption. Now we open the floor for the manifestation of the justice members.
Madam Chair.
The Honorable Suwan.
Madam Chair, to reiterate, the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of this committee. Sufficiency in substance does not require proof of guilt. It requires proof that the charge is worthy to be heard. So, it alleges bribery, which is among one of the most serious constitutional charges that can be leveled against a public official. A charge which, by its very nature, demands the highest degree of factual specificity, which means, Madam Chair, that in the complaint there must be contained very specific factual allegations which, if you read them together, they will be considered as bribery, and that this bribery must be connected to the Vice President and not just to her subordinates. And that is what we would like to find out today from the endorsers. So with that in mind, Madam Chair, may I request the endorsers, either Chairman Benny Abante or Deputy Speaker Paolo Ortega, to kindly identify which specific ultimate facts in the complaint directly attribute the alleged act of bribery to the Vice President and not just to her subordinates.
The endorsers are requested by the Honorable Suwan to cite the specific facts that constitute the offense of bribery. This is with regards to our third ground of the fourth impeachment complaint. I understand that this pertains to the giving of envelopes to the DepEd officials, which are the same videos that were played in our yesterday's hearing. May we hear from the endorsers?
Madam Chair, numerous DEPs and acknowledgement receipts, list of payees, could not be verified by the PSA. It was very much well chronicled during the hearings. Lumabas po yung mga napakasikat po na mga pangalan. If naaalala nyo pa sila Mary Grace Piatos, sila Miggy Mango, I'm sure all of you are familiar with this. Certainly there were ghost beneficiaries or conduits for diversion, and the presence of duplicated names, repeated handwritings, patterns, and receipts dated 2023 to 20, but claimed 2022, and the expenditures indicated fabrication and backdating designed to conceal the true disposition of these funds, Madam Chair.
Honorable Suwan.
Madam Chair,
The Honorable Abante. Your question, Honorable Suwan, is about bribery.
Allegations in the complaint which talks about, which if you take them together, will amount to bribery. And can these be connected directly to the Vice President?
So just for the record, the Honorable Suwan is asking about the specific acts that constitute the offense of bribery as cited in our third ground of the fourth impeachment complaint. The Honorable Abante.
I remember, Madam Chair, that we have conducted the hearing in the Committee on Good Government, chaired by Congressman Joel Chua, of which I was the Vice Chair. And there, we have actually heard and exposed the allegations of bribery. For example, like the allegations of monetary gifts to DepEd officials. Nabanggit na po kahapon yan yung mga pangalan. There are witness statements and documentary patterns indicate that monetary gifts or payments were distributed to DepEd officials holding procurement-related functions, creating a plausible nexus between payments and favorable procurement outcomes. Of course, sa amin, such conduct, if proven, constitute bribery and corrupt influence in procurement processes. Now, of course, there are procurement irregularities na amin din pong ipinakita doon sa Committee on Good Government. Oo. Bribery and procurement corruption violate RA number 3019 and other procurement laws and regulations. So, we could be able to submit later on, Madam Chair, all of the names. Of course, yesterday, ay pinag-usapan na po ito, even the names have been mentioned, Madam Chair and Congressman Suwan.
Honorable Ortega.
To add lang, Madam Chair, the DepEd records show the procurement actions and the contract of awards that coincide with the temporarily with the suspicious payments and their transfers as well.
Madam Chair,
Honorable Suwan.
is there any evidence attached or annexed to the complaint which would support these allegations? Just for formality's sake.
We have annexes here of the bribery and everything. In fact, we have acknowledgement receipts to the tune of 50,000, 30,000, 100,000. You could be able to see it here.
I wish to share to the members that the video are part of the evidence to support the fourth impeachment complaint. May I just confirm this from the endorsers? The videos that were played yesterday, videos of Yusek Mercado, Catalan, and Osayas.
Yes, that is, Madam Chair, that is what we're referring to.
So we're stating for the record that those videos played yesterday forms part as well of the evidence in support of the fourth impeachment complaint, specifically with respect to the third ground.
Yes.
The Honorable Suwan.
Madam Chair, are there documentary evidence attached to the complaint regarding this allegation of bribery?
Yeah, Madam Chair, we have already said that there are a lot of documentary evidence here that I'm holding.
And are these documentary evidence certified through copies?
There are acknowledgement receipts, as I've said a while ago, Madam Chair, and I believe that Congressman Suwan can come over and be able to see all of the documentary evidence that we have. Napakarami kasi, no? It would take time for us to be
From the endorser, if the attachments pertain to the COA documents.
I believe so. In fact, if we could be able to actually even call upon the forensic review of all of the accounts and expenses that have been done by the Office of Vice President.
Honorable Suwan.
Madam Chair, I am asking these questions because I believe that the standard of sufficiency in substance exists for a reason. It is not to make things easy. It is not to make things hard. It is to make things honest. That is all, Madam Chair.
Madam Chair?
Thank you. The Honorable Rodriguez.
Thank you. Madam Chair, in Article 3, it is quite surprising because it puts in the allegation itself on the impeachment grounds, two grounds which are not in the Constitution. Articles 1 and 2 is really precise because they, for example, Article 2 is betray public trust and graft and corruption. Here, they have included procurement irregularities. It is not part of the 6 grounds as enumerated in the Constitution, nor common responsibility. Probably, this should have been the parenthesis in support of graft and corruption and bribery. In other words, Article 3 are really on graft and corruption, number 4 in the list, and of course, and then bribery, third in the list of impeachable offenses. Now, Madam Chair, graft and corruption, there is no recital, nor about bribery. They are still saying that they will be proving later on. There is no bribery. Is really governed by the revised penal code, whether on a criminal level or as part of the to support the impeachable offense of graft and corruption and bribery. And so therefore, Madam Chair, there is no recital of facts in this. So, graft and corruption, bribery, there is no clear recital of facts of how. Well, the elements are conducted so that it will clearly show that there was the sufficiency in substance. Now we go to procurement irregularities. This, together with bribery, are on DepEd. I will not anymore. Following the chairman's decision, I will just state that we have no jurisdiction on bribery and procurement because DepEd, that's it. We will not elaborate that. Command responsibility, Madam Chair. Command responsibility is a doctrine that was adopted way back in the Nuremberg trial of the Nazi. That was the start of command responsibility. Even if they did not be the one to kill Jews and everybody, in that particular case, the Nuremberg court convicted them, Goering, all the others, because of command responsibility. So that is a doctrine started by war crimes in the Second World War. And then, Madam Chair, this doctrine was extended to crimes against humanity because of the Srebrenica massacre in the former Yugoslavia. And so now, these doctrines are really related to war crimes and crimes against humanity. Now, the thing is, the Supreme Court, Madam Chair, has extended this to the Philippine situation, in the Supreme Court case, where it's true that this started as war crimes and so forth, but if there is a showing of 3 elements, and one of them is that there is knowledge of conspiracy, then it can be used. However, I do not see here this conspiracy by the Vice President with those who were implementing, allegedly, these illegal acts. So therefore, Madam Chair, very clear that Article 3 is utterly insufficient in substance. Graft and corruption, no recital, bribery, procurement, no jurisdiction, command responsibility, there is no statement of conspiracy. Thank you, Madam Chair.
Any other member who wishes to
Chair.
comment on the third ground?
Madam Chair.
The endorser, Honorable Ortega, is recognized.
Quick response lang, Madam Chair. During the past hearings, We have seen the procurement records. Nakita naman natin yung mga records dati and how they are linked to instances with suppliers, yung connection nila sa mga recipients, sa mga suspicious payments, mga receipts sa awards. Ginamit po itong procurement para pandiskarte, para mailabas po yung mga kailangan. Siyempre, pag yung supplier, kakilala, ka-close nung mga tao connected sa mga nagpapasupply, siyempre, may nagagamit po na pera dyan, may pinapasok na pera. So, the procurement was part of the scheme. Yun lang po, Ma'am Chair.
Thank you.
Madam Chair,
The Honorable Abante.
I might agree with Congressman Rufus on the conspiracy angle, no? But I would think that there is command responsibility and direct participation. It might not be Gestapo-like, but of course, yung mga staff ng Vice President will not act on these things without direct participation. Hindi naman pwedeng gumawa sila ng mga bagay-bagay na hindi alam ng kanilang boss tungkol dito, Madam Chair. Yun lang po.
Madam Chair.
Madam Chair, just to answer...
Honorable Rodriguez and then Honorable Nasal.
But here there is no... Can I am I recognized?
Yes, you're recognized.
Precisely. Madam Chair, what is stated here is command responsibility, not direct participation. So if you go through the recital of facts, it is not what the Honorable Abante has said, because it is, if you will read here very clear, it is stated here, it's about command responsibility. It would have been different if he was have said direct participation. It is not alleged here the direct participation, Madam Chair, of the Secretary on the employees of the DepEd. And again, once again, there is no jurisdiction of this committee on all this bribery and this procurement, because these are DepEd. He acting as Secretary. Duterte versus House of Representatives, the Constitution, Administrative Code of 1987, it should be acts done by the Vice President in relation to her office as Vice President. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
The Office of the Vice President Disbursement Voucher and Liquidation report bear respondent certification and approval. Pangalawa, when we had the hearing in the Committee on Good Government, the staff testified that they acted on instructions from the head of agency. Ito naman po regular naman to sa lahat ng institutions This fact support, ano yun? Direct liability. The head of agency who approves and certifies disbursements, who instructs SDOs to turn over cash to intermediaries, cannot disclaim responsibility, Madam Chair. Thank you.
I just wish to invite the attention of the Justice members that yes, in yesterday's hearing, the Honorable De Lima read and presented the certifications signed by the Vice President as attesting party to the DepEd official in support of the utilization of confidential funds. I believe this is with respect to the military officers. So that is for the
Madam
record.
Chair, we did not anymore try to repeat all of the evidences here because the evidences have been already talked about and discussed yesterday. Tama na po siguro yun.
Thank you.
Point of order, Madam Chair. Point of order. Madam
There's
Chair,
a point of order. Honorable Defensor.
may I bring up again our rule that this is only a determination based on a recital of facts in the complaint. And it is only a determination of sufficiency in substance. Let's save this for trial. Let's hear the members, but let's do it quickly, based on the intentions of our framers to expedite impeachment proceedings based on the Constitution.
The point of order is sustained. The Justice members are reminded to confine the deliberation to the determination of sufficiency in substance. The Justice members are further reminded that the discussions on the same grounds in the third impeachment complaint have been adopted. So kindly confine your manifestation to new matters only. The Honorable Tino.
Thank you, Madam Chair. Madam Chair, upon reading this part of the fourth complaint, I would say that the allegation of bribery and procurement lacks a recital of facts. No, let me read. The only time this complaint mentions bribery is in paragraph 171. And it says here, witness statements and documentary patterns indicate that monetary gifts or payments were distributed to DepEd officials holding procurement-related functions, creating a plausible nexus between payments and favorable procurement outcomes. Okay? That's a good starting point. However, there is no further elaboration or narration of facts as to which officials in particular were bribed, what particular transactions, if any, were involved, the amounts, and so on and so forth. So, medyo, in this case po, ay wala na pong ibang narration of facts eh. Kaya medyo kulang po. Unlike in the third complaint, na nakapangalan po yung mga opisyal ng DepEd na allegedly tumanggap and so on and so forth. So, yun lang po ang obserbasyon ko dito. Medyo kulang yung narration of facts, which is required in order to substantiate the ground of graft and corruption. Yun lang po ang obserbasyon ko rito.
The manifestation is noted. Any other manifestation?
Madam Chair.
The Honorable Nasal.
Thank you, Madam Chair. Article 3 alleges bribery, pero gaya ng nilinaw sa PBBM proceedings, bribery requires the pleading of a complete quid pro quo equation. Ito ay nangangailangan ng malinaw na paglahad ng mga sumusunod. An identified bribe giver, a specific official act influenced. Magkano ang naging usapan?
Point of order, Madam Chair.
At isang malinaw na
There's a point of order. Let's hear the point of order first. Before we proceed, the Honorable Ridon is recognized.
Mula po kanina, yung ating pong kaibigan, si Congressman Nazal, ulit-ulit niyang meron po siyang reference to the BBM impeachment complaint relating to these things, no? Pero umupo po tayong lahat eh. It was just like 2 weeks ago, Madam Chair. Pero I don't remember any reference of these particular types of discussion to the BBM complaint. So, maybe I have forgotten it, maybe I have misheard it, but I'm quite certain that the 2 points that our colleague had stated had absolutely no reference to the BBM impeachment complaint, Madam Chair. I think what was clarified, and it was I who clarified it, is the point that mahalaga po yung usapin ng personal knowledge at authentic documents sa mga usapin po sa pag-uusap po natin. And nothing more. So I think we have to direct our good colleague to clarify as to which particular reference to the BBM impeachment complaint has he been referring to in this particular instance and in the previous instance that he had referred to in the BBM impeachment complaint.
The Honorable Nasal, please respond to the point of order.
I will cite the specific rulings done during the previous.
Is it your intention to enlighten the committee about the difference in the procedure with regards to, in comparison to the last impeachment hearing against the President?
The intention, ma'am, is to just be consistent with all the rulings that were held during the previous.
You may proceed.
No, just to be clear, Madam Chair, I don't think anyone's stopping our colleague from saying his manifestation. I think what needs to be clarified is that I don't think the BBM impeachment complaint standard has no relevancy. Provide today in the previous discussion that is stated and the previous discussion that is stating now. Kasi nga ho, the standard that has been discussed last time was very specific to the matter of authentic documents and personal knowledge. Wala ho tayong pinag-usapan, labas pa ho roon.
With all due respect, it was pronounced by the chair during the start of our impeachment proceeding against the Vice President that we will be adopting the same parameter, the same procedure that we used in the impeachment proceeding against the President. So,
Yun lang naman po ang hinihingi natin, ma'am.
if you have a clear disparity to point out, yes, you may proceed, Honorable Nasal.
I was just pointing out, referencing to certain actions done during the previous hearing, ma'am.
Kindly point out the disparity that you have observed so far.
Wala naman ako sinasabing disparity, ma'am. I was just pointing...
Well, if there is no disparity between the previous and the current proceeding, perhaps you should just go straight to your manifestation.
Yes, ma'am.
With respect to our third ground, which
I
is
was
the
not
subject
pointing
matter
out,
of our
ma'am, to
current
any disparity.
deliberation.
I was just saying, I was just referencing na,
All right.
na dapat pareho lang.
I think the chair has to rule, Madam Chair, because allowing him to proceed without ruling on the point of order would basically impinge on our previous proceedings.
The point of order is sustained. The Honorable Nasal is enjoined from making reference to the impeachment proceeding against the President. Please go direct to your manifestation in relation to our ground for impeachment, subject matter of our current deliberation.
Okay, ma'am. I'll just continue. Pag binasa natin ng Article 3, it alleges movements of funds and operational handling, ngunit hindi nito malinaw na tinukoy ang isang corrupt agreement, hindi rin nito tinukoy ang kung anong official act ang di umano'y na impluensyahan, at wala rin malinaw na aligasyon ng personal benefit na natanggap ng respondent. Nalang daloy ng pondo ay hindi otomatikong nangangahulugan ng bribery. Conclusions of law cannot replace ultimate facts. Tulad ng paulit-ulit na ipinatupad sa prior sufficiency determinations, narrative detail alone does not cure the absence of essential elements. Dahil dito, Article 3 likewise fails to meet the required threshold of sufficiency in substance. Thank you, Madam Chair.
Thank you, Congressman Nazal. There are no other members who would like to make a manifestation on Article 3. Bribery, procurement irregularities, and corruption. Any member who wishes to make a manifestation on this article?
Mr. Chairman.
Congressman Rufus Rodriguez.
Again, Article 4 does not provide for the six grounds for impeachment. Only one, bribery. In the title of Article 4, it says bribery, procurement irregularities, and related corruption. These are not found in the Constitution. Only bribery. And then, there's a parenthesis down there which says Department of Education, Transactions, and Monetary Gifts. In other words, again, as a whole, just to, not to belabor the point, but just to state that my continuing objection to the jurisdiction of this committee on acts of former Secretary Sara Duterte in the DepEd. Plus, Mr. Chairman, there is also no clear recital of this bribery, to whom, how much, who gave. In other words, there is completely no recital in these things. And so therefore, I would say that Article 4 we have no jurisdiction and has no recital of facts, and therefore should be dismissed. Thank you.
Your continuing objection is noted, Congressman Rufus Rodriguez. Congressman Santay.
Yes, Mr. Chair, while I maintain the same position that her actions as DepEd Secretary should have no bearing in this in this impeachment complaint, I would like to further elucidate on Article 4 on the alleged bribery. Now, ang Article 4 ay nagsasabi may bribery sa DepEd procurement activities. Ang pangunahing allegation, respondent distributed monetary gifts and other advantages to certain officials of the DepEd connected with procurement activities. Nagpakita pa nga tayo kahapon ng 3 video pero kahit dun sa video yung ipinakita ng 3 opisyal na nagbigay ng mga statement, hindi rin malinaw kung paano naging bribery ang alleged envelopes o monetary gift. Yung kay Mercado, dun sa pinakitang video, sinabi niya nakakuha siya ng envelope, parte raw siya ng back, pero dun sa narration niya, in fact, meron raw bidding na hindi natuloy. So, para saan yung pera? Hindi rin naman pala natuloy yung bidding. So, si Osayas naman, sinabi niya, hindi siya, may nakuha siya, pero hindi naman daw sa membro ng BAC. Hindi rin sinaad kung ano yung pinagawa sa kanya. Sa bribery, kailangan ipakita ang quid pro quo. May binigay na pera o benefit, kapalit ng specific official acts. Sa complaint, binasa natin to, hindi pinakita kung anong procurement decision ang allegedly binili. Hindi rin malinaw kung ang mga acts na ginawa ng DepEd officials ay hindi talaga parte ng kanilang regular duties. Kung ang ginawa ng official ay expected functions of their office, mahirap i-frame yon as bribery. Mas lalo pang lalabo kung ang allegation ay dahil sariling statement lang ng mga taong ipinakita. Kung hindi niya binuksan ng envelope, hindi rin malinaw. Kung may pera nga sa loob, kung magkano, kung anong laman, well, that was based on the statement of Mercado. Pero ang kailangan ipakita natin, meron bang ginawang kapalit at saan nanggaling yung pera? Because there was just an assumption that it came from DepEd funds. Thank you very much, Mr. Chair.
Thank you, Congressman Santay. Any other member who has a manifestation on as far as Article 4 is concerned? Congressman Chua.
Thank you, Mr. Chair. Mr. Chair, we have discussed this issue thoroughly yesterday, and I think we should move on to the next ground. And I maintain my position with respect to Article 4. Thank you, Mr. Chair.
Thank you, Congressman Chua. Any other member? There being none, then we proceed to Article 5. Unexplained wealth, SALN violations, bank records, and financial forensics. Any member who wishes to make a manifestation on this article?
Yes.
Congressman Rufus Rodriguez.
Mr. Chairman, here there is no statement. There is no proposition that one of the 6 grounds or more of the Constitution has been violated. Unexplained wealth is not in the Constitution. SALN violations is not in the Constitution. Bank records, financial forensics are not in the Constitution. However, let's take this. As probably I will now be able to assume, arguendo, that this may be to be able to support the betrayal of public trust. But, Mr. Chairman, the problem with Article 4 is that there are absolutely no recital of facts constituting the offense charge, because we don't even have the offense charge. There is no statement of either culpable violation of the Constitution. Second is treason. Third, Mr. Chairman, is bribery. Fourth is graft and corruption. Fifth is other high crimes. And sixth, betrayal of public trust. Nothing in Article 5 of this fourth impeachment complaint. So clearly, there is no recital of facts. How is there unexplained wealth? There is no statement that the Vice President received so much money and has deposited so much money, has acquired so much properties, that there is unexplained wealth. because this is also defined under Republic Act 1379, RA 1379, which is the civil forfeiture of illegally acquired wealth. Nothing. Nothing on this. Also, there is no statement of SALN, which SALN violations? Because in the third complaint, it was the SALN from 2007 to 2017 as she was vice mayor and mayor. But nothing on SALNs from 2022 when she became president, vice president, June 30, 2022 up to now. Nothing. There's no statement here. So the second will again fall, the violations. Bank records, what bank records are you talking about? There is no attachment of any bank record or any statement of bank record. And then, financial forensics, this is something that is a matter of evidence, not as a ultimate statement of facts. So therefore, Madam Chair, that is why, you see, that is why they are requesting, if you go to page 59, you look at this. This is not a recital of facts. What does it say? It's 59. 247 paragraph. To determine the existence and extent of unexplained wealth and SALN violations, I respectfully request, Attorney Cabrera, respectfully request that the Honorable House of Representatives, through the appropriate committee, take the following actions. Issue subpoena. We are not yet there. The only problem with this is a clear request for a fishing expedition against the Vice President. So very clear. In Article 4, there is nothing that recites facts that will lead us to say that there is a sufficiency of substance. And therefore, very clear, what do they ask here? To order a preservation of vault inventories. Can you imagine that in this particular proceeding already asking for us to fish? And then we also to authorize coordination with COA, the Bureau of Internal Revenue, Anti-Money Council. But they have to first recite the statement, ultimate facts constituting. There is none, Madam Chair. So therefore, clearly, there is a particular, by a very face, on the face, in the four corners, under positive law, where you can only look at the four corners, like in this case on finding substance, we have to look at the statements in the four corners of the document. And there's nothing there about all of these allegations. So therefore, Madam Chair, Article 4 as Article 5 as Article 4 false. There is no sufficiency in substance. Thank you, Madam Chair.
The Honorable Po and then the Honorable Suntay.
Madam Chair, of course, with due respect
Madam Chair,
to the previous...
may I be allowed to answer after Congressman
Yes,
Suntay?
you will be called after the Honorable Suntay.
Madam Chair, with due
You may
respect to my colleague and someone I believe is very knowledgeable when it comes to the law and the Constitution, I'd like to cite that Article 11, Section 17 of the Constitution is clear that public officers are required to file a true and complete statement of assets, liabilities, and net worth. And this is not a minor administrative requirement. It is a constitutional duty grounded in public accountability. So at this stage, our task, Madam Chair, is quite limited. We're not determining guilt, and we are not conducting a forensic audit. We're deciding whether the allegations are ultimately true. So we are determining sufficiency and substance. And what I have noticed and what I have observed here in this complaint is that, as our honorable colleague has mentioned, there seems to be no SALN copies, no bank records, and no forensic financial reports attached to this complaint. However, I wouldn't say it's a fishing expedition. So if I may ask some points of clarification to our sponsor, our colleague, Rep. Abante, I'd like to ask...
The endorsers' attention are invited regarding questions to be raised by the Honorable Po.
To further give, I guess, light to this issue, may I ask what specific transactions, properties, accounts, asset increases are being cited indicative of unexplained wealth? Or maybe are there particular SALN years where material omissions were alleged?
May we hear from our endorsers?
Well, to add, Madam Chair, the complaint narrates that the forensic records of the VP reveal glaring discrepancies as to the inflows and the transfers of funds in her banks, and as compared to her declared income in her SALN po. These discrepancies do not account by any lawful income or declaration of gifts, thereby giving the rise for reasonable inference or originated from illicit resources, Madam Chair.
You are referring to the income of the Vice President vis-a-vis what appears in her account. Honorable Ortega, may we hear your confirmation?
Yes.
Madam Chair, which account? Which bank records? Because we are here, ultimate facts. Which bank account, which bank record are we talking about here, if it's stated here? Because I have read this thoroughly 3 times already, and I did not see any.
Madam Chair.
Yeah, but maybe ask first our endorser, because we have to have ultimate facts. When you say bank records, then you have a duly authenticated bank statement given by the bank.
With all due respect to the Honorable Rodriguez.
Yes, ma'am.
Let us all be reminded of the bank secrecy law. While the bank account is significant, I think we are not in the position to expect the complainants to provide specific details of these accounts in view of the bank secrecy law. And we all understand that impeachment proceeding is the only avenue by which the complainants may be able to look into this and perhaps avail of the documents necessary to support this specific ground. That is for the record. The Honorable Endorsers are recognized to respond to the Honorable Rodriguez.
Therefore, the need for forensic financial review, Madam Chair.
Madam Chair.
Let's go back to the Justice member who raised this question. The Honorable Poe is again recognized.
So continuing on that point and manifestation, since there are no documents or bank records that could be cited, was there maybe any sworn testimony, public disclosures, audit findings, financial statements, or comparative SALN data over the years that may have been used as the basis for this ground?
The Honorable Poe is asking about the specific documents or evidence in support of the 5th ground of the 4th impeachment complaint. That is in view of the bank secrecy law. What therefore are the evidence so far attached or considered in support of the 5th ground of the 4th impeachment complaint?
Madam Chair, it would not be automatic for us to be able to tell those banks no because of the bank secrecy law. That's the reason why itong pinag-uusapan natin, yung impeachment complaint na ito, lalabas po ito sa trial. We are not yet in the trial. We are just talking about the sufficiency of substance dito. Meron bang sufficiency of substance na pinag-uusapan natin? Meron. But in everything in this, I would like to tell our colleagues here, no, na this will all come out in the trial, in the impeachment court. You see, yun po ang nais kong sabihin sa lahat.
The Honorable Rodriguez.
In answer to my good chairman of the Committee on Human Rights, there has to be a recital of facts. And in a recital of facts, there must be a reference to testimonies about bank accounts, if we cannot get the bank accounts. In other words, there has to be a nexus of the statement about irregularity in SALN and bank records by having itself the bank records, the SALNs. And so therefore, it is totally devoid of any particular recital of facts, because that is what we need. We cannot go further if there's no recital of facts constituting the offense charge. Because in fact, You know, the statement of Honorable Brian po that there is a requirement in the Constitution of SALN, whatever it is not in the 6. To construe the constitutional provisions, you are very much limited to the enumeration. Use them generis. If it's not in the, it's not in the enumeration, it cannot be a ground. So, again, culpable violation of the Constitution. Second, treason. Third, bribery. Fourth, graft and corruption. Other high crimes, betray public trust. No statement about having an inaccurate or untruthful SALN as a ground for impeachment. So that is what we have. We have to therefore have that. So just to be able to respond to the statement that there is a violation of the Constitution that is culpable. It is not, Madam Chair. In fact, those in the SALN can even be able to reform and refile a corrected one. Madam Chair.
The Honorable Defensor,
Madam Chair.
and then the Honorable Abante.
Thank you, Madam Chairman. The most democratic way to settle this, whether there is a recital of facts or not, is to follow the rulings of the Supreme Court that in impeachment proceedings, each member is allowed to decide for himself how to appreciate the recital of facts or the evidence. And the best way to do that is by voting later on. So let's proceed and let's not stall anymore. Thank you.
We invite the attention of the members to the manifestation of the Honorable Defensor. There is no quantum of evidence required in determining the sufficiency in substance, and in the case of Merceditas Gutierrez, it has been upheld by the Supreme Court that the decision rests to the exclusive judgment of the individual members of the Justice Committee.
Madam Chair.
I think that rests our discussion
Madam Chair.
on this specific ground.
Let me just answer.
The Honorable Abante.
As an endorser, no, let me just answer the statement of Congressman Rufus. Of course, not being a lawyer, but of course, a very good student of law, no, legal doctrine, as explained in the case of Gutierrez, nabanggit na kanina, no, versus HOR, a Committee on Justice. An impeachment complaint is sufficient in substance when it recites facts that, assuming the truth, constitute an impeachable offense and are determinative of the committee's jurisdiction. Yun po yung binanggit kanina ni Congressman Lawrence. It is not yet a full-blown trial on the merits. Because sufficiency in substance, as has been said, requires a recital of facts that, assuming the truth, sapagkat lahat po ito allegations pa lang assuming the truth constitute an impeachable offense and establish the committee's jurisdiction. Therefore, an impeachment complaint that is conclusory, fact-bare, or effectively unsupported despite verification is vulnerable to being found insufficient. Yun po ang gusto kong sabihin, no? Now, pinag-usapan niyo yung recital of ultimate facts dito. The fourth complaint that we are endorsing is sufficient in substance because it does not rely on mere constitutional labels or generic accusations as accused by Congressman Rufus. Hindi lang ito basta nagsabi ng betrayal of public trust or culpable violation kang walang detalye sapagkat nakalagay na po lahat di ba? Instead, it pleads a concrete recital of facts constituting the offense charge and determinative of the committee's jurisdiction. Sa madaling salita, may malinaw na salaysay na mga pangyayari, may petsa, may halaga, may dokumento, at may testigo. Hindi ito puro haka-haka o opinion lamang. So in particular, the complaint alleges a public admission on 23 November 2024 regarding contracting an assassin, for example, together with the Alice non-retraction and reiteration of that statement. It situates these allegations within their factual context, security implications, legal theory, expressly invoking culpable violation of the Constitution, betrayal of public trust, and other high crimes. These are constitutional ground for impeachment under the 1987 Constitution. Ibig sabihin, hindi lamang sinabi na may kasalanan. Ipaniliwanag kung ano ang sinabi, kailan sinabi, paano ito nakaapekto sa seguridad ng bansa at bakit ito pumapasok sa mga grounds of impeachment. The complaint likewise alleges, allegations pa rin, ano po, specific confidential funds transactions and supporting particulars, including, for example, pinag-usapan na kahapon to, 125 million in cash on December 20, 2022. ALE's liquidation within 11 days. ALE's COA disallowance of 73,287,000. ALE's irregularities such as duplicate pays, PSA certifications of non-existent records, and fabricated receipts. And it also cites unidentified affiant, Ramil Madriaga, and references relevant documentary records. Mahalaga ito dahil may eksaktong halaga eksaktong petsa at tinukoy ng mga dokumento at affidavit. Hindi ito simpleng akusasyon lamang. May mga kalakip na ebidensya at pangalan ng testigo. These particulars matter dahil sinabi ng Korte Suprema na, I quote, mere allegation is not evidence. And that verification presupposes reliance on documents and other pertinent records supporting the allegation. So madaling salita, para po maunawaan din ng mga ordinaryong kababayan natin na sumusubaybay sa atin ngayon, hindi pwedeng puro salita lamang. Kailangan may batayan. At dito may tinutukoy ng mga dokumento at opisyal na record. Nalalabas po yan. Hindi lang po siguro natin pwedeng sabihin 24 hours, lalabas ka dito. Meron po tayo sinusunod na batas tungkol dito. So finally, the fourth complaint alleges discrete acts of obstruction of oversight, including, nabanggit na po kahapon to, refusal to answer questions in House hearings, Alice instruction to COA not to comply with a subpoena, entry into House premises during detention days. Marami pong mga bagay, mga colleagues, Madam Chair. Yun lang po ang gusto kong sabihin dito.
Madam Chair.
Thank you.
Madam Chair.
The Honorable Po, then the Honorable Chua, the Honorable Suntay, and the Honorable De Lima.
Thank you, Madam Chair. Madam Chair, the reason why I asked earlier about the sworn statements, etc., is because I believe what the endorser was saying about the Madriaga complaint served as the trigger for this ground, no? And that basically I'm asking these questions to show that if we are allowed to proceed to merit, we immediately would be able to determine whether or not this ground really does stand. Because, as mentioned earlier, there are certain documents which would be critical to this ground, which, if they were disclosed, would immediately determine the innocence or the guilt of the parties involved. Which is why it makes a strong argument as to why we should move to merit already.
The Honorable Po is saying to proceed with our impeachment proceeding to be able for us to know
just a
the
short
veracity of the
answer,
allegation on this particular ground. Honorable Abante, kindly wait until
just a
the
short
Honorable
one,
Chua is finished.
Madam Chair.
Madam Chair,
Abante,
Can we call the witnesses? Can we ask the committee to call the witnesses? Because we can call them.
that will happen after the determination of sufficiency in substance.
Madam Chair.
The Honorable Chua is recognized.
Thank you, Madam Chair. Madam Chair, considering that the rules of court is suppletory to the rules of impeachment, then probably the remedy is if there is vague allegation, the remedy is for the respondent to file a bill of particulars. Or, probably, Madam Chair, is for her to put it as an affirmative defense in her answer. And then later on, it can be answered in a reply by the complainant. That is the remedy, but not to dismiss this ground or this case. Thank you, Madam Chair.
The Honorable Suntay.
Thank you, Madam Chair. Well, as correctly pointed out, under Article 5, the allegation states, respondents engage in conduct indicative of unexplained wealth and material non-disclosure of her SALN. Pero ang malaking problema, pag tinignan natin, hindi naka-attach what SALN we are talking about. Kung walang SALN na naka-attach, walang baseline para makita natin what was allegedly omitted. Ano yung inconsistent? Then I was looking, going back at the complaint, there is no recital eh. So paano natin malalaman which inconsistencies are we talking about? There is 811 pages dito sa complaint. Karamihan ng attachment, acknowledgement receipt, PSA certification, DepEd certification, isang audit memorandum at saka notice of disallowance. Pero both the SALN and the bank account being stated, wala naman. Merong allegation of unexplained wealth, pero hindi rin sinabi dito anong basis nung unexplained wealth. Which property are we talking about? What acquisition are we referring to? Without all those things, then the narration of facts is incomplete. There is no nexus, Madam Chair. Thank you very much.
Our parliamentary status is we are determining the sufficiency in substance in line with the fifth ground of the fourth impeachment complaint that corresponds to unexplained wealth and the SALN of the respondent. The Honorable De Lima is recognized.
Thank you, Madam Chair. Just a brief point. Ultimate facts do not pertain to evidentiary facts. So SALNs, bank accounts, bank transactions are evidentiary facts. Now, just to address the belief of some that there is absolutely no averment of fact in relation to Article 5. May nakita po akong isa. I was still trying to look for more because this is a lengthy pleading. Paragraph 76. And paragraph 76 is found under the statement of facts, antecedent facts. And that is before the discussion on the articles, the main discussion of the articles. So we cannot segregate what are discussed or laid down in that portion of statement of antecedent facts with the discussion now. So paragraph 76, as I said, this can fall under a narration or a statement of an ultimate fact. What does it say? Public records and investigative leads indicate the existence of bank accounts, property transactions, and other financial movements that are disproportionate to respondent Sara Duterte's lawful income and not fully reflected in her statements of assets, liabilities, and net worth. Isn't this an essential, material, ultimate fact that can be supported, substantiated during the evidentiary stage of these proceedings? Thank you very much.
The Honorable Nazal and then the Honorable Rodriguez.
Thank you, Madam Chair. Pag binasa po niyo itong mga nakalagay sa Article 5 regarding unexplained wealth, SALN violations, bank records, and financial forensics, nakalagay lahat sila based on assumptions in preliminary documentary leads, hindi po solid proof. It keeps saying that a forensic review will uncover unexplained assets, but as of now, wala naman napakita yung complaint. Wala man lang attachments na kahit ano to prove itong sinasabi na unexplained wealth. First, the complaint talks about supposed discrepancies in the SALNs but differences in reporting do not automatically mean someone was dishonest. Hindi po ako abogado, but I'm an economist. Bago po ako naging congressman, alam naman po natin na property values change. Assets can be bought or sold at different times. To immediately label this as pattern of concealment without clear proof of intent is unfair and speculative at best, Madam Chair. Second, kailangan daw po ng forensic financial review to reconcile declared income and assets sa SALN. Identify unexplained inflows or transfers and trace the disposition of public funds alleged to have been diverted. Hindi ba dapat po trabaho ito ng complainant na mapakita ng ebidensya sa reklamo niya para maging sufficient in substance? Third, the complaint points to large cash disbursements from confidential funds and say these correlate with certain financial movements. But yung mismong complaint admits in paragraph 237 that correlation is not conclusive. Suspicion based only on timing does not prove personal gain. So, mag-i-impeach po tayo ng Vice President na binoto ng 32 million na tao na Pilipino dahil lang sa suspetsa. Third, the mention of intermediaries, third-party accounts, corporations, or relatives is likewise made to sound suspicious. But many lawful transactions are done through representatives or business entities. These arrangements are common and legal. Dapat man lang may katibayan o matter, not on what has clearly been proven now. Allegations and suspicions are not the same as evidence. Thank you, Madam Chair.
Next is the Honorable Rodriguez.
Yes, thank you, Madam Chair. With due respect to our new Deputy Minority Leader, she tried to explain Article 5, which has zero recital of facts, unexplained wealth, SALN violation, back records, and financial forensics, by going to the statement of facts. And that's she's right, that we can cite that. However, what does paragraph 76 state? Are these recital of facts? I will read, Madam Chair, and it is for all of us to determine whether this is a recital of ultimate facts constituting the offense. It says here, public records and investigative leads indicate existence of bank accounts. What are these public records? What are these investigative leads? You know, Madam Chair, you can see here, the fourth impeachment complaint is really a big volume of annexes. There is no annex on this particular, what are the public records? Nothing. See? What are the investigative leads? There has to be statements. You cannot just say, for example, that there is draft and corruption without also stating the ultimate facts constituting that. You cannot just say, malversation. You cannot do that. There has to be a statement of facts. Now, you say public records. What are these public records? To give us an indication that there's a crime has been committed, that a impeachable offense has been committed. Nothing. And then it says other financial movements. Very vague. Other financial movements. There are a lot of financial movements. In the stock exchange, in the trade and commerce of people. So, what are these financial movements? And they say that are disproportionate to respondent Sara Duterte's lawful income and not fully reflected in her SALN. Which SALN? 2022? 2023? 24? 25? No statement here. It's a general blanket statement. These are not recital of facts. So therefore, paragraph 76 does not support Article 5. So once again, there is absolutely no, that's only insufficient, nothing, no substance in Article 4. Thank you, Madam Chair.
Madam Chair,
Honorable Ridon.
we'd like to, before indulging...
Before we proceed, may I just acknowledge first the Honorable Paolo Henry M. Marcoleta from Sagip Party List.
Before indulging our good colleague, Congressman Rodriguez, on the public records that is actually looking for, I'd like to read for the record the articles of impeachment of the Corona impeachment process, in which former Chief Justice Renato Corona was convicted, and SALN was one of its bases, no? It was a very general narration of the facts, and I think this should be the same standard, because this has undertaken the entirety of the process of impeachment, from the express route towards final conviction at the level of the Senate. So I will read it. Madam Chair, (2.4) Respondent is likewise supposits. It has been reported that respondent has, among others, a 300 square meter apartment in a posh, mega-well. Has he reported this as he is constitutionally required under Article 11, Section 17 of the Constitution in a statement of assets and liabilities and net worth, SALN? Is this acquisition sustained and duly supported by his income as a public official since his assumption as associate and subsequently Chief Justice? Has he complied with this duty of public disclosure? We are stating it for the record, Madam Chair, because this is the precise wording of the Corona impeachment articles of impeachment, which had proceeded to the Senate and had resulted in a conviction, Madam Chair. So I think it is very clear that this is the process that we have to undertake, and what the endorsers would want to undertake during the process of full proceedings can be undertaken. It does not require what our colleague is actually asking today. It would be good had the annexes been there, but is actually not in fact required for full impeachment proceedings to proceed. But I think the crux of the matter is, what is the definition of unexplained wealth, Madam Chair? Because I think this is something that we would want to be able to talk about as well. Yung pong unexplained wealth, mga kaibigan, meron pong very specific definition yan sa atin. An officer and employee acquires property during their incumbency. So if we are talking about the Vice President, from 2007, from her first year in public office to date. And second element is the amount of property is manifestly out of proportion to their official salary and other confirmed local income. And at this point, I will indulge our colleague about the public records on which this committee can actually take judicial notice of. So I will read to the record, Madam Chair, the totality of the net worth of the Vice President from 2008. 2008, filed December 31, 2008, net worth 18,493,617. SALN 2009, net worth 18,281,000.
May we be clarified, Honorable Ridon, of the reference from which you are reading?
Well, we have the references of the SALNs themselves.
That is the
Madam
SALN
Chair.
of the Vice President?
And some of public information relating to the
May
SALN.
we know specifically which document
Well,
is
I will
that?
present for the record the most recent SALN that had been filed. I think it's on the screen, but I think what should be noted is the original SALN net worth, which was 18 million.
With the indulgence of the Justice members, we will be flashing on screen the document which is the reference of the Honorable Ridon.
Yeah, but to have a starting point, Madam Chair, the original SALN 2008 is 18,493,600. December 31, 2008. So we will be flashing 23 and 2024. May we request, Madam Chair, that the Secretary be directed to flash?
For the record, the SALN from which the Honorable Ridon is first referring to is the 2008 SALN, which provides for an 80 million net worth. And we will be flashing the 2023 and 2024 SALN.
Madam Chair, this is the 2023 SALN. We can proceed to see the totality, the net worth, Madam Chair. 2023, can you go down further, please? A little bit down. Ayan, net worth po. Net worth for 2023. 77,508,841 pesos. This is for 2023, Madam Chair. Can you flash 2024, Secretariat, please?
Kindly flash the 2024.